Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. A small, stoppable law firm or whatever it is. I don't know. I can't say I'm unstoppable, but tenacious law firm. This is, of course, Lawsplaining the Interwebs, as stated, a production of Rekieta Media, LLC. And, we're here for Thursday. It's a Thursday. What even is Thursday? I don't know. I don't know what a Thursday is that matters. I don't know anything about that. We're just here for some lulls. We're here for some mild education, hopefully a little entertainment. Oh, I'm just getting things set up, sorry. And we're here to talk about this. We're still talking about the Vic case. Now, tomorrow, of course, we will not be talking about the Vic case very much. Maybe it'll get mentioned, I don't know. But Drexel, I believe, that's the plan, is that Drexel will be joining me. It'll be the 75,000 subscriber stream. I'll be eating a Carolina Reaper pepper. Lots of sadness and sorrow will be had. We'll probably talk about snack trays and all sorts of other fun things. Whatever Drexel's got on his mind. When he's here, I kind of just let him run and roll along with it, because it's always an interesting ride. It's always interesting to see where he's going to go in the show. And what antics I'm going to get to learn about from my friend of 20 years. Like, where? What? what was this? Okay. But that's what's going to happen. I hope you did get a chance to see the thumbnail. The thumbnail is, of course, two wonderful individuals. No, that is not me. That is not me. In the picture, that is Justin Trudeau. If you're not aware, people are remembering that Justin Trudeau has culturally appropriated all sorts of Aladdins and other things. He's just, blackface is fine if you're Justin Trudeau, I guess. But maybe not. Maybe Canada's mad at him. I don't know why they would be. Who cares? Who cares? It's an old picture. But because of Justin Trudeau, and because I can't stand being either confused for a Canadian or confused for Fidel Castro's son or confused for a socialist mongrel like Trudeau, I'm bordering on disavowing my own picture, which I haven't done ever. Never disavowed it, but I'm close. Trudeau is pushing me to the end. But for now, I remain steadfast. And the other person, there is another person in that picture. I don't know if any of you guys know who the other person in that picture is. I'm going to wait just a second. And if the chat wants to spam who the other person in the picture is than Justin Trudeau, go ahead. I don't know if you guys know that picture. I don't know if you guys recognize that picture. I wouldn't normally recognize that picture, but if you do, go ahead and throw it in the chat. Otherwise, I'll tell you in just a minute. No, I'm not seeing it yet. Very interesting. You had to see the thumbnail for the show to see it. Okay, it's Evan Stone. Not that Evan Stone. Not Evan Stone. A little bit shorter Evan Stone, if you get my drift. This is Evan Stone, head counsel of Funimation. Or, well, I shouldn't say head. In-house counsel for Funimation. Notorious pirate chasing IP attorney Evan Stone. is the man in the picture. Now, that's Funimation's attorney. That is John Volney was hired by Funimation to do this trial, or to do this court case, but John Volney is outside counsel for Funimation. Evan Stone is in-house counsel for Funimation. And Evan has some very interesting history. I'm not going to do like an Evan Stone expose tonight or anything like that. That's not what this is about. If Evan happens to see this now, like if he's watching live, hi Evan, I doubt it. But if he is watching live, he may recognize where that picture is from. And in 55 minutes, you guys will recognize where that picture is from too. Okay, that is, I've teased it out a little bit. I'm not hyping this one, right? This is not like the audio releases that we had. Those were very salacious audio releases with some very, very not very 2019 language in them and stuff like that. I have a video for you today well, it'll be tomorrow, I guess, technically at midnight. So now 54 minutes. We'll play a video. It's 27 seconds long. And it involves Mr. Evan Stone. And it's YouTube, don't shut me down because this is not a porn video. I know I keep saying a video that involves Evan Stone, but it's not that. It's not that at all. There's no nudity. There's barely even real people in it, okay? And the real people who are in it are arguably not people. But no, it's nothing salacious or scandalous. However, there's some real questions about this video. And we'll play like trivia time at midnight for those questions. And see if you guys can figure out why this video might be interesting. Hold on. I got to introduce a friend yesterday to the proper way to drink whiskey because they've only ever had whiskey straight out of a flask. And when you're a pro, you drink whiskey out of a flask, or when you don't care, or when life is just that great, you just drink whiskey out of a flask, and that's okay. But if you really want to enjoy like a whiskey that you're paying more than $8 for, you got to take it in phases. And I got to expose a friend to that yesterday. And so I'm just, That's good. That's good. Okay. That's the Alabama bourbon. Alabama bourbon. Okay. So here's the thing. But anyway, so briefly back to the video that's coming up at midnight. This is not one I expect to trend. I don't think this is going to like blow up. It's not going to, Funimation won't be waking up to a deluge of social media or anything like that. But the right person seeing it could be pretty interesting, or maybe not. Again, I don't know. And we'll ask those questions when we get to the video. We'll talk about it. What else are we doing today? Okay. If you have been following this thread on the Kiwi Farms, the Vic Mignogna versus Funimation LLC lawsuit thread on Kiwi Farms, there's been a lot of discussion. There's been two very bright anti-Vic lawyers, presumably. One's called Law Twitter Throwaway, so and is consistently arguing legal positions as if they know what they're talking about. So possibly a lawyer. And then the other one is like Dinky Sow Cow or something. I don't know, but constantly arguing why they're retarded. One of those two people, or those two people, are in the thread. They've been talking about this. Law Twitter hasn't been talking about this as much. They've had a couple mentions of it, but we're going to talk about this idea of an appeal bond. So we'll talk about the appeals process. We'll talk about the appeal bond in just a second, because appeals on TCPA are very, very complicated, and they have a lot of different rules about them. And so we're going to talk about an appeal bond. And what was funny today was I posted, there's a Supreme Court decision in Texas, and you don't need the Supreme Court decision, okay? Like I posted just a head note from a Supreme Court decision that basically says that on appeal, when you're posting your appeal bond, attorney's fees don't count. They're not included in the appeal bond at all. That's it. So when you appeal, briefly, we'll talk about this more in a second, but when you appeal something in Texas and there's a judgment made against you and you appeal it, you either have to pay the judgment or you have to post what's called an appeal bond, which guarantees that the judgment will get paid. Okay? What they don't want is someone getting a judgment against them of like $100,000, appealing that judgment, and then draining all their money and not being able to pay the $100,000 that they would have otherwise been able to pay. So they're forced to post that $100,000. Now to do that, to post a $100,000 bond, you either have to post the cash or you hire a bondsman, sort of like a bail bond. And you give them a percentage of the cash, you guarantee the rest of the funds personally to them, and they put up the full amount via a bond. Okay? And they can charge interest and all of that stuff, and however they're going to do it. So the prevailing narrative lately has been that, well, if Vic appeals, he's going to have to post $1 million worth of attorney's fees and sanctions because the judge hates ties so much that he'll sanction infinity dollars, and they'll have to post an infinite amount of bond up on to the court to even try to appeal. You're screwed. Ha 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 ha. That'll be great for Vic losing all that money right away. Well, the bad news is the remedy, of course, is attorney fees, which are not compensatory damages. And that's what the appellate rules of procedure requires, compensatory damages. And the court has found in multiple cases that attorney's fees are not compensatory damages, and specifically in the context of posting bond. So it's called a supersedis bond, and we'll talk about it. We're going to talk about that, and we're also going to talk in conjunction with all of this. We're going to go through the very short transcript of the hearing that happened on Tuesday. The transcript is out. We're going to go through that transcript. And we'll talk about some ideas and theories and speculation about things Chup said in that transcript. Because there's a bunch of people out there, one of them with the lowest T ever, who I believe have read into that transcript incorrectly. Now, they'll disagree with me, but remember when I pointed out that he doesn't have to post attorney fees on appeal bond, even though this is settled Texas law, even though that it's there's several Supreme Court decisions backing it up, even though it's the plain language of the rules, even though there's the plain language of the statute also saying it, they all said it was wrong just because I said it. And when I laughed at them, because they're like, where's the citation? I'm like, yeah, go find it. I don't care. And I actually hinted at several places they could find the exact phrasing that they needed. These people still insisted I was wrong. And then throughout the day, they were slowly being corrected by themselves, by other attorneys, by anybody who could read all of that stuff. And they had to sit there and try and find other ways that I might have been wrong about it by projecting their own mental incapacity onto what I said. So these same people have made comments about how the appeals process works and how fast some of this appealing action would go. And then yet I think they've got it wrong. So maybe not, though. Maybe not. We'll talk about it. So that's the show agenda tonight. I'm going to hit the initial super chats that have come in, and then we're going to, the $20 ones or whatever, and then we're going to go into the show and just get rolling. And then in 46 minutes, we will do that video clip. It is not a long clip. We'll discuss it a little bit. It's not going to be like the other ones where there was a whole show of discussion about it. I just want to make sure everybody knows when I'm going to play that clip, just in case they want to pop in for that. So we'll do it. Let's go for it. Hold on, let me move a couple things. Let me move a couple things over here. I see. Can I do this? I can do this, can't I? Does that? That's all I need to see. What am I even worried about? YouTube changed the whole like live streaming setup, so I'm learning all this new fancy stuff about the software that I use all the time. Remember to have Drex read the mall cop email to Monica? Better not blue ball us again. I don't blue ball you at all. What are you talking about? All right, anyway, here we go. And then these. It says, usually my Friday afternoons are spent drinking while in video conference with work. Sadly, that isn't happening today. But what's a better opportunity than to drink while watching your stream? Here's to you and yours. Hey, cheers, buddy. Down in Australia. Yukishiro Rai. We're going to do this one right now because I see it and I don't want to miss it later. Money for a drink to my birthday before midnight if possible. If not, still cool. Better than drinking alone. Yukishiro. I don't know if my emphasis is correct. To you, buddy, happy birthday. Cheers. Okay. So there you go. Cheers to both of you. Tucker says, I hear Trudeau is out. Good job, Canada. Is Trudeau actually out? Is that a real thing? That'd be great. That'd be funny. Hopefully you won't get even more blackface with your next guy. And they said Rob Ford was a problem. Matt Rosenfield says, love the thumbnail. I'm Canadian and stoned. Can't wait to vote conservative next month. Hey, cheers to you, buddy. Good luck. Joskby says, I DGAF about blackface, but since my prime minister is King Cuck, head of the NPC clap along, and throws hardworking people's money around, I'm loving every bit of lashback that he gets. Hashtag not my prime minister. And is he getting lashed on the back? Does that go along with the cultural appropriation he's already doing? Is that a bad joke? I don't know. I don't know anymore. Because jokes are sometimes bad and sometimes fine. And I think it really just depends on your politics, whether or not the joke is offensive or not. Tucker says, debating anti-gunners on Twitter is going to give me cancer. That actually does. When you do that in California, you get a special pop-up message that says, warning, debating these morons could actually cause you cancer. And then finally, Jarrell Navarro says, did you see Jamie's tweet about Chup telling her that her case is still dismissed? Wouldn't it be a shame if it turned out that kind of communication isn't allowed? Cough, cough, ex parte communications. I think she said her lawyer, Sam Penis, as I'm calling him, I think she said that he clarified that she's still out. And Jamie is certainly, her cause of action, the cause of action against her are dismissed, according to Chup's bench ruling. Now, he can roll back that bench ruling. He can reconsider it. He can change that ruling. He can, in his formal written order, he can do that. But we're going to talk about exactly what Chup said in that transcript. We're going to talk about that. And then we'll, of course, get to explore a little bit about what that means, what it means. I guess I'll get that loaded up now. Let's see. All right, here we go. Hold on. I'm pulling this up eventually. Doop-a-doop-doo. Oh my goodness. That. Oh, download. There we go. Come on. This is great. High-speed downloading is occurring. What is this? Can we get rid of this? This is distracting. Oh, there it is. Okay. Okay, sorry. Oh my goodness. Can I just... I'm bad at window placement, guys. I'm sorry. Hold on. Almost there. Okay. Where are we? Oh! No, the fly! There's a new fly. Oh, gosh. It keeps landing on my arm. Rude. Rude. Okay. So, where are we? Here. Come on, Streamlabs. Ah! See if we can get this up here. There we go. Now I just have to shrink it down a little. Okay. Can I just get this correct, please? Oh my god. There we go. Almost. Okay. Aha! I think we've got it. I think we've got it. Not too disastrous. My apologies. Okay. Stupid Streamlabs. So here's the background information. If I leave Streamlabs open overnight and like have my computer go to sleep or whatever, then when I load it back up, if I don't close Streamlabs out fully and then reopen it, my monitor capture that I usually use, which I'm going to have to figure out because I'm supposed to use it for this thing, but I will. My monitor capture shows up just black like that, like blacker than Trudeau's face. Just terrible. Just miserable. 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 Just miserable. Okay, so here we go. We've got the hearing transcript here. So be it remembered that on the 17th day of September 2019, the following proceedings came on to be heard in the above entitled and numbered cause before the Honorable John P. Chup, judge presiding, held in Fort Worth, Tarrant County, Texas. Proceedings were reported by machine shorthand. Machine shorthand. So, appearances. Appearing for plaintiffs, we had Mr. An Lee Soo, Mr. Ty Beard. Appearing for we also had Mr. Jim Bullock, Miss Carrie Elisa Christie. So there we go. We had all four lawyers there. Appearing for defendant, we've got John Volney for Funimation. Appearing for defendants Monica Rial and Ronald Toye, we got Mr. J. Sean Lemoyne. Notice that there is no other counsel there. Kind of interesting. Appearing for defendant Jamie Markey, Mr. Samuel Harris Sam Johnson. Samuel Harris Sam Johnson. Okay, so we have the caption, appearances, proceedings, adjournment, and reporter certificate. This is only an 11-page document. We're already on page 4. This is about a 5-minute long hearing. 5-minute long hearing. So let's take a peek at this. Oh gosh. Someone did some hashtags down here at the bottom. We've got hashtag New Shane, hashtag $3,000 CPAP, hashtag I wish I were Nick, hashtag too bald for a beard, hashtag what Texas bar exam. Where is that Texas lawyer registration there, T. Greg? Where is that? Hashtag master grifter. Hashtag famous podcast. Hashtag law school bankruptcy. Oh no. Oh no. Okay, so proceedings. proceedings. So here's what we're going to do. We're going to read through these. When I find an interesting specific thing that I want to talk about, I'm going to pause, and I might tangent off into talking about the appellate procedure, because that's going to tie in with something the court says, and also something that Low T has actually asserted as well. And I think that he's absolutely wrong on it. Of course, I didn't know he asserted it because little bitch boy blocked me, like he blocked everybody. Low T has blocked me. So I don't even, and I must actually say, it was very rude of me to call you a name just now. Thank you. Thank God for blocking me. I am so tired of seeing everything you post because it's so stupid and so voluminous that it's just pitiful. And I'm glad to not ever have to see it again. Thank you. All right. So here we go. The court. So they come in, they sit down. Judge, I've handed. I think I just RIP'd the fly. I flicked and it hit him. So that's pretty devastating to a little creature. Maybe it's still alive. I don't see his corpse anywhere, so who knows? Hashtag rip if you did die. Sorry. I hope you didn't drop into my drink. That would be disgusting. No, they're clear. Okay. I'm gonna get demonetized for animal violence now. Okay, I've handed all counsel of record some documents that were sent to me by the sheriff's department. So let's get some conspiracy theories out there right away. I'm curious if there's an incident report on this, because how did these documents get to the court via the sheriff's department? Is the sheriff's department monitoring the tweets? Are they? Because that doesn't seem like the type of resources that the sheriff's department is normally expending to pay someone to monitor random Animu Twitter accounts. And there's been some allegations of improper communication between Jamie Markey or her counsel and the judge. Now, I don't have any information to back that up, okay? I'm not making that allegation. I'm going to address it. And the reason I'm going to address it is because the list of tweets that was provided as threatening tweets, of which, again, I believe 0 of them are actually a threat in any sort of real sense. In any legal sense, legal threats are very specific. But I don't suppose that the sheriff's department is monitoring that. Now, one email did come into the Tarrant County Courthouse. That did happen. And so, since an email came into the Tarrant County Courthouse, we can infer that the sheriff's department, who runs all of the security for the Tarrant County Courthouse, would have actually intercepted that email and maybe brought that to the judge's attention. As for the tweets, the interesting thing about those tweets is, of course, they mirror a series of tweets that Jamie Markey posted about why sexual assault victims don't come forward, which, of course, is nonsensical, because this has nothing to do with sexual assault victims coming forward and has everything to do with a couple of people lying very publicly and repeatedly and boisterously, and to the point where it kind of looks like those lies weren't ever intended to convey any sort of sexual assault at all, but much more likely seem to be rooted in some sort of professional jealousy and just generally disgusting behavior from some washed up voice actresses. I mean, but that's just my opinion, I suppose. If Jamie Markey is, because again, even taking her story at its worst, he grabbed her hair, pulled it in. It's not even a sexual assault. It's a simple battery at that point. But you know, this chick is not talking about being a sexual assault victim in any real capacity, right? ask an actual sexual assault victim if even what Jamie described compares to the trauma that they went through, and then you might have to pay for their next couple therapy sessions. So just absolutely ridiculous. But those same set of tweets are the tweets that Judge Chupp provided to the attorneys present in the room as the list of threats, so to speak. So we're not quite sure exactly how Jamie Markey's perception of threats gets handed directly to the judge. Now, maybe Jamie filed a police report, and if she did, that should be on file with the Tarrant County Police Department. And I probably will be making a phone call to them tomorrow to see if I can acquire a copy of that incident or police report. Because it would be a real shame if there was a communication made directly to a judge, for example. And again, I don't know if that happened, but I assume if the police took a report of threats to be credible enough to actually pass them on to a judge, that those police would probably create some sort of incident report about that. And I'll be inquiring about that tomorrow. Because, there should be no problem issuing a police report, even if they redact who sent it, just that somebody issued one. Okay. And like I said, I want y'all to be aware that this is out there if you're not aware of it. This is interesting. I don't know if there is any potential threats to you as lawyers or your clients, but I think you need to be aware of it. Why? Very weird. This is very weird language, okay? And here's a thing that Chupp is doing right. Well, let's just go on a little bit further. I think there is a community out there, obviously, that is interested in this case. Well, how obvious is it, Chupp? I think it might be, this isn't a TV show. This is real life stuff. This isn't an anime cartoon or something like that. And I don't know if people can distinguish between the two. So apparently, Judge Chupp is suggesting that the greater anime community, or even the micro anime community that's interested specifically in this case, might not be able to discern the difference between reality and an anime, which I think is a little bit, I'm not saying it's malicious. It's just indicative of how out of touch judges are with insular communities. I talked about this a long time ago, a long time ago, at the beginning of talking about Vic and analyzing the case and starting to get into how this stuff works out. I did mention that a judge is a person who's likely disconnected from a fan community like this and won't know as much about it. And so part of the challenge that a lawyer has is to bring all of this stuff into the context for the judge. And it's a really hard thing to do. Imagine how hard it is to explain to your parents, grandparents, your friends, a football player or whatever, someone, and I don't mean someone young, because anime and video games and role-playing games, all of that is becoming mainstream. When I went to high school, very different times, right? Video games, I went to high school. When I was in high school, Halo came out, and I see Halo as a tipping point in nerd communities where suddenly video games became mainstream enough to be cool. Right? And you had a literal intersection of segregated communities in the high school population interacting over something like Halo, where they couldn't have done it even 2 months prior. They just didn't. There wasn't that overlap. But the jocks and stuff, they all had an Xbox at home, but they didn't talk about playing it a lot. But then this thing came up and it kind of built a bridge between those communities. And in the ensuing almost 20 years, maybe 20 years now, since Halo came out, we've seen video games, we've seen anime move from these niche communities into mainstream culture. So nowadays, a kid in high school, a lot of different people are going to have at least seen some anime. Dragon Ball, of course, is one of those bridges. Full Metal Alchemist, these major productions are going to cross those barriers. But someone in their 40s, late 40s, 50s, even early 40s, you're getting to a time where they grew up when this stuff was segregated out from them. And if they grew up in the wrong area, it may not have been just segregated out. It may have been non-existent for their community in general. So, sorry, these tangents will happen here and there as I muse on this stuff. But anyway, it is a little condescending, but giving Chup some grace. I think he underestimates just how the anime community has changed since he would have ever contacted it as a Ute. Tucker says, I live in California. I've seen that cancer warning. Rip me. In other news today, I found out that engaging in rational debate with someone means I'm a Russian troll bot. Well, of course. All I can say is hail the Soviet motherland, comrades. There you go. So what I'm back to Chup. So what I'm trying to say is I think y'all may owe a duty to this community. For the record, no. The lawyers in the case do not owe any duty to any community at all. That's a silly thing to say. Since y'all's clients are part of it. Now, their clients may owe a duty to community, but the lawyers do not. To try to get this case worked out. Is anybody opposed to trying to get this case worked out? Y'all can speak. She's typing. Okay, so Chup is now asking for input. Are y'all open to negotiating this out? Mr. Beard says no, Your Honor. No one else answers. That's interesting, right? We don't know how long elapses between these lines. We just know he says, is anybody opposed to trying to get this case worked out? Y'all can speak. She's typing. Ty says no, Your Honor. We don't know if he's looking at Ty. Is anybody out there opposed to that? Like, that's one way to take that, right? That the judge is looking at Ty and his team and really just thinking that Vic is not opposed to mediating or settling. Which, if Chup's paying a bunch of attention, which of course he can't have been paying this much attention, he'd know that it's the defendants who have said over and over again that they won't settle. And it's the plaintiffs who have suggested that the best interests of the defendants would be and would have been and have always been to settle. I mean, if only there was some lawyer that they were trying to suggest was controlling the case from 1,000 miles away who had said, y'all should really settle this out. The best option is to settle. It's always best to settle. And it's funny. Again, this is another one of those instances where the big meaty brains on law Twitter have used my statements that it's best to settle the lawsuit, which have been consistent from the start, have tried to use those statements to suggest I'm intimidating people, to suggest that I'm saying things that are nonsensical or whatever, to now them saying, well, of course the judge would suggest settlement. Settlement would be the best option for all parties, and the parties all have an interest in settlement and all that stuff. It's amazing how this keeps happening. But, I mean, on one side there's me, on the other side there's a mix of barely people and disingenuous cucks. So I don't know, but it is amazing how that keeps happening. But of course, settlement is the best option in a civil suit almost all the time. Almost all the time. It mitigates risk. It's more efficient. It saves money for everybody. Something I've said from the beginning. Can't afford this. No one can. Don't waste your time. Don't waste your money. All right. No one else answers. So I don't know if Chup is just staring down Ty's team when he's asking this, or if the other people are genuinely uninterested in settling, which I think they are, but are afraid to say yes or no. Because they're afraid, I don't know, of just vomiting instantly. They don't know why they're in this meeting. None of them knew why they were coming. They just showed up and then Chup hands them these things. All right. Court says, okay, there's a lawyer in town that handles some mediations that are a little more sensitive and deal with other issues than just legal issues. Every lawyer handles issues that are other than just legal issues. you're basically doubling as a therapist, a financial advisor. Like, you just are, because people start to trust you when they're your clients and they come and ask you other questions. Now, they're obviously, you can't give them therapy, but you can sit and listen to them lament, and you can try and suggest a legal option. And typically you couch that with, you know, there is a legal remedy for this, but maybe your better option is to go talk to X, Y, and Z about Z or whatever, in honor of Trudeau Z. Okay. No, this is not the mediation. This is the hearing that where the mediation was ordered. Okay. So he says, I think this case deals with things other than legal issues, obviously, because people are interested in it for some reason. His name is David Seidler. So I'm going to order you to go see David Seidler. A judge picking a specific mediator is a little weird. And here's my thoughts on it. There are a couple avenues, okay? Either Chup thinks that this guy's capable of actually mediating this out. And I don't know if Chup thinks that. It depends on how much attention Chup is actually paying to this. But I don't know if Chup, I mean, he would know. Think about this. From the TCPA hearing on the 6th, everybody came into that hearing hot. The other attorneys are accusing Ty of fraud. Ty is accusing them of breaking the rules. The judge is telling everybody that he doesn't care and they're not listening. And all sorts of people are making arguments that have nothing to do with TCPA. All of that's happening. I don't think Chup thinks that this is actually like this congenial sort of kumbaya, right? I don't think he's suggesting that. But maybe he is. Maybe he thinks Seidler can actually handle it. The other possibility is he knows Seidler. He knows Seidler. And while mediation communications are privileged, I'm not sure that there's an express rule prohibiting the judge from hearing about what happened in mediation. Now, attorneys all assume that judges are not supposed to know what goes on in mediation. But at the same time, I think a lot of attorneys, at least who've experienced mediation and then gone on to practice in the same case after mediation fails, have found that maybe the judge's tone or demeanor changes, or maybe it's like the judge kind of figured out or heard maybe what happened at mediation, right? Maybe Judge Chup knows David Seidler and might have a conversation and might be trying to get more information about the prospective positions of the parties, which to me sounds improper, but I don't know that there's an express rule against it. I really don't. Maybe there is. And if there is, if you know that rule, feel free to call me wrong. I'm not making a claim either way. I'm just saying I'm not aware of that rule. I know the conventional wisdom is that mediation is privileged, but it's typically privileged against using statements in mediation to influence the outcome of a case, because the idea is that you approach mediation with candor because your offers cannot be used as an admission of guilt. For example, like your offer to settle, like, well, we'll pay you $3 million, doesn't mean that you believe you caused $3 million in damage. That's not what it means. It means you're willing to pay $3 million to make this go away. Those are different things. And so you can't make that offer, have them reject your offer, and then come back and cram it down your throat at a hearing. That's not how mediation works. But I don't know that that privilege actually precludes the court from hearing about it. So it's possible that the judge wants the mediation as an opportunity to get some judicial perspective on where the respective positions of the parties are. So, but we don't know. Again, this is speculation based on what Chup says. Some of these things I find very interesting. So I'm going to order you to go see David Seidler. I'll give you the information, and you need to do it before October 3rd. because I still have to rule on the rest of the motions by October 6th, I believe, or 5th. The 3rd is a Thursday, so that will allow me to rule on Friday if y'all don't get this worked out. This is apparently what Sharon Grigsby misinterpreted as the judge saying he would rule on Friday if they don't work it out. That's not quite what he says. That's the inference that she drew from it. So that will allow me to rule on Friday if y'all don't get this worked out. Yeah, it will. Now, there's some debate going on Kiwi Farms and in other places as well. But a lot of it's on Kiwi Farms over whether or not the judge has to issue a written order to make his verbal orders effective. Short answer, I believe, is no. The case law in Texas suggests that a clear order given from the bench is a binding and effective order on the day it's given. Now, if you ask a bunch of practitioners in the area, and maybe even if you ask the judges in the area, they would suggest, many of them do suggest, and we're actually kind of enlightened by this news, many of them suggest that a judge issuing an order from the bench is not actually a final judgment or a final ruling on the issue, and that the judge's typical practice is to actually render a written decision later. And many times that written decision is different from the decision granted on the bench. In fact, there's some Texas practitioners out there who might be taking this and using it to now take those bench rulings that they get in their favor and ram them down the judge's throat when he offers a written decision that's different, but doesn't actually strike his original decision. So he's not overruling himself. He's just ruling differently than he ruled in court. They can suggest that, who knows? Who knows? But that's kind of how the practice works, is a lot of attorneys and judges would consider the written decision to be the final actual decision and the non-written decisions to be almost temporary. But that's not how the law reads. I want to be very clear. The case law says that a definitive ruling from the bench is a ruling. But you have to determine if the judge intended to rule definitively on the matter. So judge saying, I think, or I will, or I might, or it looks like, those aren't definitive rulings on the issue. Okay? But a judge saying, this is dismissed, that's a definitive ruling, arguably. It's all an argument, right? But that's pretty arguably definitive. This is dismissed versus I might dismiss this. Those are two very different statements. So I want to be very clear that if the judge who has the authority to change his decisions does so, he will be doing so to change his decisions. But this talk is, I'm tangenting again, and I apologize, but I'm tangenting because this goes back to him issuing those rulings on Jamie Markey and dismissing from the bench is effectively a dismissal. He says these are dismissed. So he could roll those back. He could overrule himself. He could reconsider his decisions, either sua sponte or by motion from one of the parties. He can do that. But will he is a completely different question. But the reason this is important is there's something called a pocket veto, where if they don't issue an order, or a ruling, I should say, if they don't issue a ruling on an aspect of the TCPA prior to the 30 days required by statute, if they go to 31, 32, 33 days, then it goes in the plaintiff's favor and is basically appeal proof, because the Supreme Court has held that is a hard line. The hard line outside of pretty extreme circumstances. And the court can't just be late. If the court is late, then the court loses its jurisdiction under the statute to rule on the TCPA issue. So there you go. It's done at that point, and it goes in the plaintiff's favor. And on cases where that has gone to appeals, the plaintiffs have won. Now, this is very different, though, from that case, because in that case, the judge indicated how he might rule and then didn't. But in this case, the judge has ruled on several of the issues. But he could pocket veto the remaining 5 claims. He could do that. He could do that. I'm not saying he will. That is an option. All right. Let's see. Is everybody still here? I mean, I don't remember who represents who. Who do you represent? Mr. Lemoyne says, Monica Rial and Ron Toye, con sluts extraordinaire. Court says, and you are? Oh, BTFO John Volney. He doesn't even know who he is. Doesn't even know. Right, remember that? Do you remember that from Law Twitter? Right, when Judge Chupp didn't know that Ty, who he had never seen before in his life, was a lawyer representing Vic because Bullock was doing the hearing. Remember the big deal they made out of it? John Volney has been in front of this court at least twice. And I think he's been present in the court 4 or 5 times now. And the court looks at him and says, and you are? Doesn't even know he exists. I guess John Volney is probably Funimation, just the client, not a real lawyer, right? Idiots. Oh my God. God, there's a movie. It's an intentionally crappy movie. There's like a skeleton that mind controls a monster and stuff. And they're talking to this skeleton. They're like, I didn't think you could speak. You look dead. And he's like, that is how stupid you are. That's how I feel about Law Twitter. That's how I feel about Law Twitter. Okay. You're Funimation. Okay. I'm Funimation, Your Honor. You're Funimation. Okay. Well, Volney apparently is Funimation. I am Funimation. Mr. Johnson says, I'm Jamie Markey, Your Honor. Wow. That's a little interesting, Sam. You cosplaying now? Is Sam the Cos Thought? Yeah. At that point, Lemoyne started salivating and said, beware, young Padawan, con slut, Cos Thought. Court says, and you're Jamie Markey, okay? Okay, so y'all need to call David Seidler, set up something with him. Where are your offices? Volney says, I'm in Dallas. He's in Plano, pointing to Johnson. Yeah, Plano. Okay, he might drive somewhere, I don't know, because y'all are coming from Tyler, right? Yes, sir. Okay, he might meet y'all somewhere in Dallas. I don't know. If that makes it easier on you, you might ask him that. Well, his address is not on here, but he's downtown. So here's an order. If you want to each get a copy, come on up. But again, just make sure your clients are aware that this stuff is going on. And I don't want them to get hurt or you guys to get hurt either, obviously. So just be aware of your surroundings. Just be aware of your surroundings. Okay, I need to... I need to start fixing the whatchamacallit. Okay, I hope that doesn't take away your thing. I've got to start fixing this monitor situation. Oh, baby! There we go. We're just going to do it this way. Boom. Oh, yeah, we've got it now. Perfect. Perfect. Okay, I fixed my technical issue. It worked this time. So he's telling them all to be safe, be aware of their surroundings. That's just great. Very cute. Oh, read the hashtags. Okay, so we've got... we left off at law school bankruptcy. We've got hashtag low T, hashtag sped douche, hashtag spurgnot, hashtag bankrupt lawyer, hashtag con sluts, hashtag fifth GoFundMe. Woo. Woo. All right, we've got 6 minutes. 6 minutes to video air. Okay, Mr. Johnson now comes in. And Your Honor, if I may, this includes Jamie Markey. You can just hear the vocal fry. This includes Jamie Markey. The court ruled to dismiss all the claims against her. I just want to make sure that cuts her off. Her. Oh, sorry, Sam. Him. The court says, I mean, I think she should show up because there's no guarantee you're not going to be back here in 3 months on an appeal. This is an interesting statement from Judge Chubb. We're going to spend a few minutes here. After the video, we're going to come back to this because I'm going to spend a few minutes promoting the GoFundMe, because let's talk about the GoFundMe, right? Tucker says, is it just me or is this judge suddenly sounding like a massive cuck? Well, we'll talk about that in a minute too. We're going to get there in just a second. But we're just going to talk about this. 3 months on appeal is a really interesting thing to say. Now, Low T focused in on this. And he says, well, 3 months on appeal, that would be if he dismissed all claims. Would it though, Greg? Would it though? I'm not so sure. We'll talk about why in a little over 5 minutes. Real quick, let's pull up the GoFundMe for Vic Kicks Back. We have, and just so you know, here we go. We've got Randy Martinez, thank you. Anonymous with a big donation. And Tahita Huff, thank you so much for your donations. We're at $248,506. We're closing in on that $250,000 mark. I think and I've been hesitant to really promote the GoFundMe. I know this is over. These signatures that I definitely forged on the bottom, that I personally forged Vic's signature on these prints. These were a nice boost to the GoFundMe. Thank you for all who participated. I am calculating the results. I hope to have them up tomorrow on tomorrow's show. I will also reach out to everybody and get their consent to use their names. But I will have all of the winners of that. I will have that figured out hopefully by tomorrow's show. That's the goal. I haven't been able to sit down and do it yet. But since the window is closed, right? But those are a great boost to the GoFundMe. Thank you so much for participating. I think, depending on how these rulings go, we may see some increase or decrease to the GoFundMe. I don't know. We'll see. We'll see how it happens. But the GoFundMe is a consistent comedic source. I don't care personally if another dollar is never contributed to it. I would leave it up for the duration, if only to remind them of how horrifying the actual response has been for them, and to remind them just how much sacred ointment they've needed this entire time, because thousands and thousands of people have donated hundreds of thousands of dollars on the idea that they lied to destroy a man. And that is exquisite. And the amount of butthurt from attorneys who have probably spent, listen, y'all, attorneys probably lose 20% of their annual income to clients who don't pay the bill. So to have a big client with hundreds of thousands of dollars guaranteed paid to someone that they hate, like Ty Beard, God, it just burns them up on the inside. They don't know what to do. They hate Ty, they hate Vic, and they hate me. And yet, here's this coffer of money that they're all jealous of. Because for a lot of the attorneys on Law Twitter, this would make their entire year in fees. I don't know how else to say it. Right? Now, some of them would make more. Some of them would make more, but on average, this would be a solid year for a solo practitioner. That'd be a great year, depending on where you are. And for many of those attorneys, billing $250,000 out would be huge. That'd be a huge case for them to actually land. So, you know, jealousy. And jealousy is always there, isn't it? Okay, what do we have here? Oh, and real quick, we're about to do the video. We're about to do the video because it is now midnight on my time. You guys are a little bit back behind me, but it's coming. I'm going to put it up in just a second. But I want to say one more thing. Many of you have asked me when Ty will be on the show. When Ty is going to come on to the show again. And I talked to Ty about it today. I said, hey, when do you want to come back on the show? His suggestion to me, from his perspective, is he doesn't, they're required to go into this mediation in good faith. And in the spirit of that, Ty doesn't want to do anything where he comes on this show and starts talking about the case in a way that would jeopardize the good faith of going into this mediation. I've said from the get-go, Ty is a business attorney. He's a businessman. The best way to resolve business disputes, and this is ultimately a business dispute, is doing business. If you think at any point Ty and Vic have not been willing to come to the table with these absolute scumbags, I mean, I don't know what to tell you. I don't know what to tell you. But just know that the rift in the anime community that we just want to heal, they've had offers. Hey, it's the 7-month anniversary today. These people have had offers or requests to engage in productive discussion for at least 6.5 months, if not 7. And remember that Ty was hired on the 20th of February, according to Vic, I believe, in his deposition. So all of this nonsense and BS about the rifts in the anime community and them just wanting them to heal, all of these people have had opportunity to do so for 7 months. And one side of this lawsuit has never suggested that settlement, mediation, and an end to all of this has been off the table ever. But one particular side has always maintained that they will not settle, they will not talk about it. No, they're going to drag this all the way to court, no matter what. And those same little soy babies are bleeding over and over about the rift in the anime community. And I told them from the start they had a chance to end it. I told them I would personally connect them with Vic's attorney before Ty was even announced, that I would personally connect them with Vic's attorney to talk about settlement. I told them all. It's been in plain language from the start. And I believe Ty has said several times on this show, perfectly willing to discuss it. Just call him. And now they're lying to the entire planet, suggesting that somehow they want the rift to heal. The only way they get the rift to heal is if Vic is dead, and then apologizes for being dead and admits to being a horrific macro rapist. That's what they've wanted the whole time. Dustin Fritz Farr says, and for law Twitter, it's more money than they have ever seen because it's obvious that they don't currently practice. Twitter is their full-time chore because let's get things right. Twitter doesn't pay bills. All right. Video time. Video time. Where are we? This it? This. Now, some of you may recognize picture. Can I make this bigger? Oh, I can. Here we go. Evan Stone for judge. Vote on November 8th. What is this? What is this? Evan Stone In-house counsel for Funimation. What's his little line says? Do your puny planet some good and vote for a candidate whose power level is over 9,000. Evan Stone. This is sent on November 2nd, 2016 at 11:38 p.m. That just seems kind of embarrassing, doesn't it? You know what I'm going to do? I'm going to run for district court judge as a lawyer. And what I'm going to do is make a Dragon Ball Z reference in my ad, right? Well, let's watch the video. Now, I told you guys. Told you from the start. I didn't hype this. This isn't salacious. Nothing like that. But you tell me if you can figure out why this video might be interesting to certain people. All right. Let me see. Oh, I'm going to put on my headphones. There we go. There we go. Oh, where is it? Did it get... Oh, here we go. That looks like... I mean... That looks like an animation. It might be owned by Toei. I don't know.
Hello, Earthlings, it's Vegeta, the Saiyan Prince. Normally I don't meddle with pathetic human affairs, but this fall, a funny, bald Democrat named Evan Stone is running for district judge, and he needs your help to defeat his lame Republican opponent. In 2004, Evan graduated from UNT with a film degree. After that, he went to law school, and now his power level is over 9,000! Please do your puny planet some good and vote for Evan Stone on November 8th. Political ad paid for by Evan Stone for judge.
Are we serious? Are we serious here? Are we kidding? I mean, okay. Can anybody figure out? Can anybody figure out what the problem with this might be? I mean, besides just being cringy, embarrassing, pathetic. Vegeta being a Democrat after giving his white power speech in Dragon Ball Super, all of that. But ignoring all that, can we figure out the problem with Evan Stone for judge? What, puny Earthlings? Now, I don't know. Okay. I don't know. Maybe they got permission from the license holder. Maybe they got permission from the license holder. I don't know if Toei Animation approved of Vegeta being, and I'm pretty sure that's the voice of Vegeta, Chris Sabat. I don't know if Toei Animation approved of their licensed IP being used for endorsement of a political candidate in Texas. And what's interesting about it is of course, that Evan Stone would probably be giving the legal opinion on whether or not their license agreement with Toei allowed them to use not only Toei clips, Toei licensed animation clips, but the intellectual property of Vegeta himself making a political endorsement using the official voice of Vegeta. Like, that seems like it's a stretch. But maybe they did. Maybe Toei and Shueisha, maybe in Japan, what they really wanted was their IP specifically being used for a political ad in the United States. I don't know if they did or not. But I think it's curious that this stuff keeps popping up. Remember, And, well, let's dig into the irony a little bit further. Evan Stone is an intellectual property attorney who spends his days tracking down IP thieves, pirates, right? Evan Stone prosecutes pirates, or not prosecutes, but he's a plaintiff's attorney against piracy. He protects the IP of Funimation. And here he is. Maybe it's all above board. I do not know. Maybe Evan would answer. I don't know. I should maybe reach out and say, hey, Evan, you want to talk about it? Want to talk about it, buddy? But if he did this outside of the license agreement, he needs to sue himself, right? Like, that's insane. Oh, man. I'm gonna play it one more time. And again, Evan, I know you go after pirates. I'm not using your video. Like, your video is not the thing that is being done in this. So I will expect you to do a proper fair use analysis and realize that this is definitely newsworthy. This is definitely for commentary. It's also a little bit for ridicule. But we're not talking about profiting off of your little video here. This is ancillary to the show. I just thought people would be really interested in this information. And I'm pretty sure, I don't know if this video link is actually active without the direct link to it. Because I've heard that this has actually been shut down, but it might be preserved through the magic of Reddit. But here we go. Let's try this. Let's play it one more time.
Hello, Earthlings, it's Vegeta, the Saiyan Prince. Normally I don't meddle with pathetic human affairs, but this fall, a funny, bald Democrat named Evan Stone is running for district judge, and he needs your help to defeat his lame Republican opponent. In 2004, Evan graduated from UNT with a film degree. After that, he went to law school, and now his power level is over 9,000! Please do your puny planet some good and vote for Evan Stone on November 8th. Political ad paid for by Evan Stone for judge. Hello, Earthlings, it's Vegeta.
Oh, sorry. It wasn't supposed to start again. All right. Well, there you go, guys. There's the video I promised at midnight. I delivered, well, like 12:03 after some exposition, but that's it. Again, not salacious like the other videos, but in their own way, maybe more egregious. They allowed someone to... A guy who's ostensibly there to protect the IP is actually using the IP for a political campaign, and maybe he got permission to do it. I don't know. He could, and if he did, great. Wonderful. If not, well, you guys want the link? I can get you the link. What do I care? Here you go. Here's the link. I just threw it up in the chat there. If you guys want that, go ahead. I don't know. Toei and Shueisha, if you're watching, you know, there it is. But yeah, it's important, of course, to know. And I don't think Evan Stone's a bad guy or anything like that. I don't have any indication that he's a bad guy either. I think this might have been a blunder. But maybe he got permission. He is a lawyer after all. Maybe he's careful. I'm not accusing him. I'm curious. I don't think I'll ever get an answer on it, but it is kind of funny. But Toei might be interested in it. And Shueisha, who is, they published the manga of Dragon Ball Z, Dragon Ball Super. They may be interested in it too. I don't know. But maybe if they already know about it, this wouldn't be interesting to them at all. So, and no, he did not win. Just like that sip of bourbon was non-existent. All right, here we go. And if anyone's curious, I believe that video has already been saved and archived by someone I know, but feel free to save it yourselves. Well, here's the link. Oh. There you go. Okay. Let's get back to this. Sabbath confirmed by comments on Facebook. You mean I'm not gonna play it again, don't worry. Oh, here's the comments. 61 comments. That's a kind of a funny one. Tom Bevins. This is funny. See, this guy does it right. View it full size. Now there's an Evan Stone I can vote for. Oh my goodness. Sorry. Oh man. All right, here we go. I'm not gonna. Well, you guys can find that. You guys can peruse through that. Links there. Okay. Oh boy. So let's get back to the document here. Let's get back to this document. Oh, there are a couple chats I should read real quick. Perception check. Hey, perception check. I meant to ask you the other day. You mentioned possibly going to Hawaii. Are you going? Are you going to HawaiiCon? You don't have to super chat it. Just tag me in the chat or whatever. Perception check says paid for. He paid Sabbath to use Toei's IP to promote Evan Stone for an election. Seems like it. Seems like it. Oh. Pyretta Riddle says, hey Rackets, can you give me your thoughts about the latest DMs I sent you? Not about conflict of interest, but about what the person said in DMs, of course. Also, con sluts rise up. I'll respond to you in private. Sure. Awesome. I'll see you there. I'll see you there. Lady Rackets and I will see you there at HawaiiCon. Can't wait. I'm getting reports that the link doesn't work, but it works for me, so hopefully you guys can still see it. Link's dead? No. Let me try a different browser. See if it pops up there. Because it worked for me just a second, like just now. No, I've still got it. I don't know why you guys can't see it. I think there's actually 6 new comments. All right. It's been clipped and is hosted on Kiwi Farms. Perfect. All right. Let's see what's next. Okay, back to this document. Back to this document. And this is interesting. So the last thing I read, and we'll talk about this. The last thing I read was this. Chup says, so Sam Johnson, let's go back just a little bit. Forgive me. Sam Johnson says, and Your Honor, if I may, this includes Jamie Markey. Court ruled to dismiss all the claims against her. I just want to make sure that, I think she should show up because there's no guarantee you're not going to be back here in 3 months on an appeal. Now, you guys will have to make of this what you will. Chup said 3 months on appeal. Let's talk about that. Intimidator0108 says, like Jamie and Monica's hate for you, Nick, the cringe power of that video is over 9,000. Looking forward to this weekend to see movies like Bennett's War and Rambo. I am pumped for Rambo. I might just rent out a theater to go by myself. I'm not even kidding. And streaming Twitch, also enjoying a little wine before bed. Attaboy. I say that very like authoritatively, like I'm super cool. But I live in a tiny town with a little tiny private theater, privately owned theater. It's not like an AMC or a Cinemark or anything like that. It's just a little 4-screen theater. And I know the manager. And so you can actually, for a fee, you can actually rent out a theater privately when they're not showing, the movies otherwise. And it's really inexpensive. I just found out it's inexpensive. It costs barely more than it would take me to take my family and like a couple friends to the movies. So we're going to do that. Anyway. So yes, 3 months on an appeal. Let's talk about appeals in TCPA. So appeals are, however I describe this, people are going to say I'm wrong. I'm going to speak in very general terms, and there are exceptions to these very general terms, okay? But here's the basic rundown of how TCPA appeals work. Vic cannot appeal the TCPA issues generally until the entire case is resolved, okay? So here's how that works. Let's say Chup right now has 5 cause of action left. He's got the 3 defamations, Funimation, Monica, and Toye. And then he's got the 2 conspiracies, Monica and Toye, right? 5 charges remaining that have to be dealt with. If Chup dismisses all of those 5 charges in his final order on the TCPA, Vic can appeal immediately. He has 20 days, I believe, from that written order to file his appeal with the Texas Court of Appeals, with Tarrant County Court of Appeals. If one cause of action survives TCPA, it has to be fully resolved for Vic to initiate an appeal. So let's say the judge only preserves defamation against Ron Toye and dismisses Funimation and dismisses Monica Rial. All of those things get ordered. The the attorney's fees are ordered to be paid, sanctions, all of that stuff is dealt with. But Ron Toye's case goes on and proceeds. Vic cannot appeal any of the dismissals until that cause of action is resolved for Ron Toye. That's how the rule works. It's a weird rule. Now, Vic can ask for leave from the court to file an appeal. He can do that. The court may not grant it. But the court may grant it. But he doesn't have a right to appeal. Conversely, if any of the causes of action survive, for example, let's say just Ron Toye's defamation claim survives, Ron Toye can appeal that immediately. He does not need to wait until all of the causes of action are rendered. In fact, any of the causes of action that survive can be appealed immediately by the defendants. They get an interlocutory expedited appeal. Okay? Now, importantly, if Vic has to appeal the final resolution of the action, which would be dismissal of all claims, if he has to do that, it's not an interlocutory appeal. And as far as I can tell, it's not an expedited appeal. TCPA appeals have an expedited process for the defendants because they got to get this. The whole point of the TCPA is to resolve quickly frivolous lawsuits, right? Like that's the whole purpose of it. Okay. So they've created a special appeals process for defendants who believe that they're being wrongly brought to court. So that is naturally expedited and interlocutory. Interlocutory means before the final resolution of the action. So here's how all this plays into this very innocuous exchange. Sam Johnson says, we don't want to be here. Judge Chupp says, you better be here because you might be back in 3 months on appeal. If Judge Chupp dismisses all the action, all of them, and Vic appeals, the odds of being back in that court in 3 months are approximately 0. Let that sink in. If Judge Chupp dismisses every cause of action and Vic loses flat out and then appeals, the odds of Vic being back in that court in 3 months is basically 0. The much more likely outcome is 9 to 12 months away. It's 9 to 12 months away. Okay? Because he would appeal all of the causes of action. He would have 20 days to file it. They would have a significant amount of time to respond. I think probably 30 days, something like that. Maybe 20 days, maybe 30 days to file their reply briefs. Then it has to get docketed with the Court of Appeals. The Court of Appeals has to do their de novo review. They have to have a hearing. They have to issue a ruling. They have to remand it. It has to get back into court. This is not an expedited process. This is the full appeals process. 9 to 12 months. These are long processes. I've been trying to say it, and they've been trying to prove me wrong the entire time. However, if Judge Chupp allows defamation to go on against either Markey, Funimation, or Toye, and they appeal, then Vic gets to appeal along with them. Are you following me? So let's say judge says, nope, I'm not dismissing the cause of action under TCPA as far as Funimation is concerned. Now Vic gets to appeal every decision that's made. And in the interest of judicial economy, since the appeals court, let's talk about this. Let's back up a little bit. Appeals court reviews TCPA decisions de novo, which means they don't give deference to the they're not supposed to give deference to the under court's decision. And they review all of the evidence. They review the entire hearing from scratch, de novo, from zero, from nothing. Okay? So if they appeal with their expedited interlocutory appeals process, Vic gets to appeal with them. And then the appeals court gets to look at everything in the expedited process and remand for a decision consistent with their determination. Now, they may decide that Judge Chupp so bungled the hearing by not issuing rulings on, say, the second amended complaint, by not issuing a clear ruling on public figure status, by disallowing evidence, not admitting evidence into, or not admitting into evidence things that were brought forth by the plaintiff, by applying an inappropriate standard like preponderance of the evidence when he should have just been looking for a prima facie case, for, say, allowing the defendants to argue against and try to controvert with evidence the evidence brought by plaintiff to make a prima facie showing, which they're not really allowed to do. They're only maybe allowed to object to admissibility. Any of those things that the trial court says, that's a do-over, because this is so prejudicial to the plaintiff, they'll have to do it over, because you can't think about this. If Judge Chupp's early decision to disregard the second amended petition is wrong, then the whole hearing has to be thrown out. The whole hearing has to be done over. Just does. Because if the court says, nope, he can have a second amended petition, if the appeals court says that he could have amended it, it's within the rules, this is how we decide that. If they decide that, then they have to do the whole hearing over, because that colored how Ty was able to make the arguments and what evidence Ty was allowed to bring at the hearing. based on that decision. So they could throw it all out. The other thing they could do is decide that Judge Chupp handled the hearing just fine. X to doubt. They could decide that he handled the hearing just fine, but that the evidence supports, proceeding on with TCPA on the following charges, or not proceeding on the following charges. They could actually render that decision, remand it back to the court to issue that order. But let me make one thing clear. The only way Markey is back in that courtroom in 3 months on an appeal is through the expedited interlocutory appeals process that happens if Judge Chupp doesn't dismiss all of the actions and the defendants choose to appeal. Now, read into that what you will. Chupp may have just been making an off-the-cuff comment. Well, you might just be back here in 3 months on an appeal. Maybe. But he may have also been considering exactly how this works out and how you get to 3 months rather than a year. All right. Tucker says, so the TCPA is a rigged dumpster fire of a law and the legislature should repeal it immediately? Got it. Yes. Yes. All right, we're going to move on. We're going to move on from that. But I really wanted to spend some time there. Now, T. Greg says, he's saying you might be back here in 3 months on appeal. That's if he dismisses all of the causes of action against Vic. I don't think that's correct. And I'm not actually being critical of T. Greg here. I'm really not. I don't think he's as boned up on the TCPA process as he pretends to be. And I'm not saying he should be either. I'm not saying that his disability-riddled moronity should be up on that. I'm not up on that. I had to look into this. I had to, it's a mess. I think he's under the assumption that if all of it's dismissed, then Vic can get the expedited appeal. That's not seemingly how it works. But maybe I'm wrong. Like I said, I'm not an expert. I've never professed to be an expert in Texas law. Never, ever, ever. So. We'll see. We'll see. But I think maybe there's a miscalculation going on there that might be causing a little bit of the boast. Okay, next. So, Sam Johnson says, I agree. The reason I asked, I have a vacation letter for next week on file, so that was why I was asking. Court says, well, somebody with settlement authority is all I'm asking for, so what law firm are you with? I have my own firm, Your Honor. Oh, you do? Okay. Yes, but I have other counsel that works for us. Based upon her standing in the case, she may be in better position than some, but I mean, I think if it happens to work out, you can do it by phone. I don't care. But here's the thing. Are they going to schedule it while Johnson's gone? Probably not. They'll just set it up for when he's back. Okay. If you need to, or have somebody else there available to be available or something. So the judge has already written the order. He hands the order to everybody in the courtroom that day. It's already written before they came in. This mediation thing. There's some speculation that Ty requested the mediation. I think that's largely been dispelled, but let me clear that up. None of the parties have requested the mediation. They would have to do that via a filing. Otherwise, that'd be an ex parte communication. Or they would have had to request it with a letter to the court that was then shared with all of the other parties who'd have an opportunity to respond. I think at this point, everybody's probably filing everything. Okay, Mr. Johnson says, and I'll be back here before the 3rd. Court says, see what y'all can work out. Yes, sir. I mean, there's no telling what the appellate court is going to do. This is an interesting speech from Judge Chupp, and we're gonna take a little time to read into this speech. Right. Now here it is. Look at this soliloquy. My son had to do a soliloquy in his drama class. They should have had him do this. I rule on stuff. Sometimes they side with me and sometimes they don't. That's just the way it goes. I don't take it personally. That's just They may have different feelings on stuff. But before I rule on the rest of it, I'd rather you try and get this worked out. I think y'all have the opportunity to heal the community by doing something that y'all can all agree on. As opposed to having me do something, then y'all having to appeal it and go through all that process, and it just comes back here again. I mean, this could go on years. I'd rather just, obviously, see the community of anime get healed and move on and do what you need to do. So that's all I needed. I just wanted to tell y'all in person because I thought it was rather serious with regards to, and I don't know what all is out there. That's just what I was given. And so there could be much more than that. I don't know. Just watch your back. All right? All right. Let's break this down. Let's break this down. We're back in 3 months. Let me clarify something. So I said in a previous stream that the judge had just been overturned on appeal, like right before this case happened. Overturned by the Texas Supreme Court in an Episcopal church property case. Now, I have not even looked at that case. I just know that I think he's been overturned like twice. Or no, he was overturned once. And then I had said he was overturned the same week that this hearing took place, the September 6th hearing. That was incorrect, and I put it out on Twitter that it was incorrect. He had not been overturned. However, what had happened, I believe on Monday of that week, is the Supreme Court, who had already overturned part of his ruling, had agreed to take up the case again. So and that case started in like 2005 or something. It's been going on a very long time. So Judge Chupp has just had a case go through his courtroom, get appealed, go to the Supreme Court. Supreme Court says, no, Judge Chupp did the wrong thing. Not a criticism. Everybody thinks judges are experts on the law. They're absolutely not experts on the law. They may, depending on what they rule on a lot, be experts on various things like marijuana possession and stuff like that, something they see all the time. But like a lot of these, like TCPA, Judge Chupp isn't handling TCPA cases constantly. He's not handling large defamation or tortious interference cases every week or anything like that. Got to understand the most of what judges deal with, you're going to be dealing with. Now, I don't know if Texas has a specific family court circuit, but outside of some counties have it very, like in Minnesota and Hennepin and Ramsey counties, Minneapolis and St. Paul respectively, they have things broken out into different sections of the court. So like there will be a chief judge of the housing court, a chief judge of the family court, a chief judge of the traffic court, and all that stuff. I don't know if Tarrant County or the 141st District does it that way. I don't think so. But he's getting a mix of different things. And this type of case may not come before him anyway. And especially the Episcopal Church property case is certainly not something that's coming before him. I'm not criticizing Chupp here. But Chupp may be criticizing himself because he's just seen a case that's now been going on for like a decade. Come through or go through his court twice, now going back to the Supreme Court, and he's probably thinking, oh God, it's going to come back again. And what if I screw up again? What if it goes to the Supreme Court again and I have to hear it again in another 3 years? So, this is probably informing this speech, right? He's got this looming Supreme Court case. His name is in the news more for that case than I think this case at this point. But he's got to be thinking, what if these idiots are coming back here for the next 5-10 years arguing about who raped who on Twitter? The judge does consider this stuff, and it's written all over this. There's a couple chats I need to get to. Ricky says, just because I like my scotch on the rocks or drinking Balvine straight from the bottle doesn't mean I can't read good. Don't drink shame me. No, buddy, I don't drink shame anyone. I really don't, except people who like Fireball unironically. I don't drink shame anybody. You drink the whiskey how you like the whiskey. You like it with ice on the rocks, you do that. Don't tell me to do it. I won't tell you how to drink it. I drink every whiskey room temperature, neat. I feel like that's the way it's meant to be drunk. And if you want to argue with me on that, you can. But bring your freaking fists, buddy. No. But no, I that's how I like it, because I like to get what I believe is the intent of the whiskey straight out. And I tend to end up liking that. I don't really care for cold whiskey or even mildly diluted whiskey. I don't like it. Okay. It's Cocky Onsai says, hat tip to one hand clapping. So basically, since Jamie gets out completely and Monica is not happy about that, and she gets her charges moved forward, Lemoyne could appeal, Vic could appeal, and anime betrayal happens? I mean, kind of. Kind of. And I think Chup knows. He's indicating to Johnson, and Sam knows too. Jamie Markey's putting on a face for public. And she's got a face for radio now. She's putting on a face for the public. But I would bet that Sam has told her that we got lucky in that hearing. But if this thing gets appealed, we're coming back. We're coming back. Or he'll say it as, there's a very real possibility that we do come back on that. And she's either choosing to ignore it, or she's not asking him and she's just going with Law Twitter. Very stupid, defendants, if you're just listening to Law Twitter. They're wrong about a lot. A lot. Listen to the attorney you pay for. I have faith that Sam's a pretty good attorney. I really do. And I'd love to share a drink with him when this is all over and all the drama's behind everybody. I hold no malice towards Sam. I think he did a great job at the hearing. But I think he knows he got by pretty lucky on that. And he knows that if Vic appeals it, there's a very real possibility, at least on the defamation, that Markey is right back in, because he even agreed, if I remember right, in the hearing, that the various things like pulling the hair, whispering in the ear, pulling her close, were fact statements, if untrue, cause damage. I think he even agreed to that. And he weaseled his way out of it by not stipulating to the fact that that tweet was in evidence, which is silly because it's in his motion. And on appeal, he's got to know that there's a very real possibility, if not a likelihood, that that statement does bring her back in, at least as far as the defamation is concerned. And he's got to be, I'm sure he's leveled with her on that. I know Jamie's a tough broad and she's talking tough on Twitter, but I think she has probably urinated through several pairs of hot pants at this point. But anyway. Okay, back to it. Damnation 3 says, I read this as Chup realizing that he messed up this hearing during the hearing, and realizing how he can fix this is by creating a situation where Vic gets to appeal along with the defendants. Possibly. The other way to read that is that he's really, really hoping they settle this out and they're catching. I think the problem with Chup is he may be too subtle for his own good, that he thinks that they're all following. And I don't think the defendants have picked up on Chup's messaging. And I could be reading into Chup's messaging myself. Like I'm fully admitting that my perspective has a boatload of bias, which I've been open about from the start, but a boatload of bias towards people making rational decisions. 2, towards the idea that the defendants have acted irrationally the entire time. I think the defendants are coming off of what they perceive as a big win, and they shouldn't see it as anything other than a win, although how big, we might argue. They perceive themselves coming off of a win from that hearing, so they hear that they're going to go to mediation, and they hear Law Twitter yapping about how they're just, the only thing they're going to be talking about is mitigating attorney's fees. I think they're going to get a rude awakening at that mediation hearing. And they're going to have to actually talk about real issues there, not just how much Vic is going to pay us. But we'll see. But I read this as Chup saying, however this works, this isn't over. If this goes to appeals, I think it comes back here. I think you're back here with your client, Jamie Markey. I think that's likely. And this is everybody's chance to get out of here before you're tied up in litigation for years, causing a rift in the community. If I'm being charitable about his statement about healing the anime community and not being suspicious about just how much it looks like Monica Rial's statements about the community, if I'm being charitable to Chup and he actually is expressing some sort of concern for how people are taking this lawsuit, then he knows these people don't want to be doing this for years. He probably also knows that Markey and Rial can't afford it. Not for years. And if they think, even if the judge awards attorney's fees, awards sanctions, it gets appealed, even if, and this is a huge if, somehow an appeals court were to determine that the attorney's fees and sanctions need to be bonded, what'll happen is that will go into the registry of the court and it will sit held in trust by the court for the benefit of the defendants. It's not like, hypothetically, Rial and Toye get awarded $100,000 of attorney's fees and they get $100,000. There is no circumstance where that happens that's reasonable. The most likely outcome is that this $100,000 bond, which is a percentage-based thing, we'll talk about that in a minute, gets posted, and it gets posted to the court who holds it pending the final outcome. Because here's what the court can't do. You can't pay them $100,000 on your appeal. And, well, we owe them $100,000 in attorney's fees. And then be appealing the decision and have them burn through that $100,000 from life or from their own attorneys or from the cocaine and hookers or whatever it is that they're going to spend it on. And then you actually get it overturned on appeal, and then you don't get your $100,000 back. That's not how it works. So if Markey, Rial, and Toye think that they're going to get $100,000 from Vic, and then they would have to maybe pay him back if he wins on appeal. No, you won't get it till the appeals are done. The judge is signaling you could be here for years, and that's true. They could be there for years. Can they afford it? Will their attorneys keep working for free? Will the community keep enduring this for years? Will conventions bring them with this drama for years? Those are real questions that they'll have to answer. If people think that they're not going to be, they may not understand their motivation to settle at mediation, but they have it unless they're stupid. And if their attorneys are at all competent. So Sam, I understand. Volney, I understand. Lemoyne, I don't think that he's going to, oh, you're going to win. It's fine. I'm an expert. I don't know that he'll competently advise them. But Sam and Volney will likely be advising their clients about the practical risks of continuing this litigation. Hey, Funimation, you're going to have Goku involved in 2020 Olympics. You're transitioning finally to Sony. The remaining 5% ownership is going to Sony. If this thing goes on, you may hit Discovery. All of those things. And oh, by the way, if any portion of this goes through for any of those defendants, do you think the fact that none of them have complied with Discovery isn't coming up immediately? You think Ty's screwing around on that Discovery abuse or the Discovery avoidance? Didn't you just go through a major acquisition, Funimation? Didn't Sony, a publicly traded company, just buy you? And don't you have a history of issues when you were owned by publicly traded companies? I mean, Navarre had issues. They purchased you with inflated stock prices, got sued on that. Did Sony purchase you? Would there be an issue with inflated stock prices, inflated valuation or revenues lingering around at Funimation? I wonder if the financial positions of Funimation will be sought on discovery. I wonder if Funimation's books, Funimation, a privately held company whose books have not been subject to public scrutiny because they're a privately held company, I wonder if there would be a request for those. And just so you guys know, as I've had to tell clients, oftentimes in a lawsuit, especially as a defendant, your financial position is relevant to the case, certainly within the broad scope of discovery in Texas. I wonder who's going to be pouring through your books. We'll see, right? Maybe we'll see. It might be there for years. I wonder if Sony has a cancellation clause for fraud. I wonder. Because see, Sony, here, let's talk about this real quick, just in hypotheticals. Sony's a publicly traded company. If Sony didn't do their proper due diligence on acquiring an acquisition that was by making an acquisition that was funded by public stock purchase or stockholders, right? If they failed in their obligations as stockholders, then they would be on the hook. However, if they were defrauded by the company that purchased them, or that they purchased, if that company were to defraud Sony would have a scapegoat in that company, unless Sony were somehow complicit in that, which that seems a little ridiculous. But if Sony were defrauded on the valuation of that company due to, I don't know, either improperly maintained books or fraudulently maintained books, then there could be a real problem. And Sony's PR answer might be to revert the contract or something like that, revert the acquisition. Now, I don't know what their purchase agreement looks like, but fraud tends to void contract. So I don't know. Maybe everything's on the up and up. Okay. Sorry. I'm tangenting. Bad habit. JXDBX says, yo, here is for last Sunday's stream. Thank you for the weekend stream. By the way, did you hear Richard Stallman resign from Freedom Software Foundation and some unknown school called Massachusetts Institute of Technology? Press F for Linux. Wait, is that the guy? Is Richard Stallman the guy who was defending Epstein? Is that him? I don't know. But why did he resign from the Free Software Foundation? Fluffy Side Up says, hypothetically, if you were Vic's counsel going into this mediation and all defendants were good to settle, what would you want Vic to get out of the settlement for it to be worth it? What would you think would be most likely? I've said for a long time what Vic should get out of Funimation, and that's clarification of what Funimation has said in court and in their filings. We did not mean to imply from our post that our investigation turned up sexual misconduct against Vic Mignogna. We apologize for any confusion. We clarify that our investigation found no instances of sexual misconduct for Vic Mignogna. That would be a stunning statement from Funimation. The next thing they could maybe ask for is, here, in the interest of transparency, what we investigated is exactly what was disclosed in the lawsuit. Jelly Bean, Twins, and then Office Kiss. If they talk about the scope of the investigation and they say that they found no instances of sexual misconduct or abuse and their tweet was not intended to imply that, that's a huge victory. I don't know if Vic even needs money with that out there. Okay, I see all your Richard Stallman stuff. I don't know. I was just asking. Like I said, I saw some headlines about someone defending Epstein or something. I didn't know if that was him or if it was someone else or if they were wrong. No comment. I don't know. Anyway, I think that's a win on Funimation. Real? God, I don't know how they settle it. There's no way I can think of that Real can walk back her statements. Vic didn't rape me. Vic didn't sexually assault me. Maybe that works. I don't know. That's a tough one. Toye? Maybe if Toye writes on a chalkboard 1,000 times, I'm a cuck, I bring the snack tray, I know the way. Just over and over, like Bart Simpson, right? I'm a cuck, I bring the snack tray, I know the way. If he just writes that maybe 1,000 times on a chalkboard, I think that's a win for Vic. Jamie Markey. Jamie should just make a statement saying, you know what? I know I said, here's how Jamie Markey's statement could read. I said in my original statement that my story wasn't as significant as others. I made my statement to support victims generally. I do not know that Vic ever actually victimized anyone. I was just supporting my friends. That's a good statement out of Jamie Markey, because nobody on earth cares what that haggard old hag says. Nobody actually cares what Jamie Markey says. I don't know that she did that much damage to him, other than the thing that lended her statement any credibility is that she'd been his co-worker for 10 years, right? If she says that, I think Vic wins. I think that's a win too. But I doubt he gets any statement out of Markey, Real, or Toye, because they're too woke to say anything. They're too woke to say anything. So I don't know that they can walk it back. But maybe just a promise to not mess with his flipping contracts, you sacks of garbage. Maybe just promise to not mess with the man going forward and just ignore him, block him, ghost him, forget he existed. That would probably be a win, in all honesty. Non-disclosure, non-disparagement agreement with a liquidated damages clause. If you don't know how that works, ask Stormy Daniels. But basically, if they have a non-disclosure agreement about their settlement, a non-disparagement agreement where they agree mutually not to say anything bad about the other person. They don't have to say anything nice. They just have to never say anything negative. So Monica doesn't get to go, he assaulted a bunch of people, or he raped me in 2007 with his eyes, or whatever it is. She doesn't get to say that anymore. And Ron doesn't get to say he's a pedo predator or whatever he wants to say. And they don't call conventions. They don't do that. And then the liquidated damages clause is very important, where they agree that if they do that, ever, then they pay out immediately like $20,000 in liquidated damages. Here's the simple question at that point that they have to ask. Can I go a year, 2 years, 10 years, the rest of my life without being an obnoxious pile of trash and trying to ruin someone's life? Now, you guys ask yourselves, because I know my answer. It's pretty simple. If I had to go the rest of my life without trying to ruin a specific person, can I do it? Absolutely. Absolutely. I'll just never talk about them again. I don't care. But can they? Can they do that? If Vic can get Funimation to walk back their statement, if he can get Markey, Rial, and Toye to just promise to leave him alone and not badmouth him to conventions, to companies, or to people ever again, he wins. He wins hands down. That's a win. Because the second Funimation walks back that statement, everything Markey and Toye have said, or no, Rial and Toye have said, is invalidated. And everyone knows it. Hell, anyone paying attention to what is actually said in the affidavits already knows that Rial and Toye were lying. They already know. So then if he can just get people to leave him alone and let him work, he wins. He wins. That's a walkaway condition for me if I'm Vic's counsel. As for money, I don't know that I care. Would I be counseling Vic is, you have a GoFundMe that's paid at least the majority, if not all of your legal fees. I don't know how much they are. You've got the majority or all of your legal fees paid for by a GoFundMe. You don't necessarily need monetary compensation. You're better situated now than you were 7 months ago. You're getting more work. You're going to have no more interference from these people. And Funimation has retracted their statement, which means that anyone who says, aren't you accused of any of this stuff? You can say, actually, no, that was a misunderstanding. And the other people were misunderstanding as well. And the people who are going to invite Vic to conventions are going to invite Vic to conventions. People who aren't, they already aren't. I don't think there's any changing. Like what a convention owner right now is thinking about Vic, there's no court action, there's no agreement that's going to change that person's mind outside of a very limited subset. Now, some of the conventions that canceled Vic canceled him because of the heat and the drama of the situation, not because they don't like Vic. Actually, I've heard that some of those conventions that canceled Vic don't believe a lick of this. And they actually think otherwise because they've worked with Vic for a long time. But what they didn't want was drama at their convention. Because it's about the fans. Some people understand this. It's about the fans, and they were scared that there would be, these big time to kill back and forth riots, right? With the KKK over here. And the black community over here yelling at each other over a police barrier. Like they thought that was going to happen at conventions. Of course it hasn't. But that's what they thought when they can't. We don't want this drama. We don't want a bunch of anime fans screaming at people and starting fights. So they canceled Vic for that reason. Those people are going to invite Vic after next year or the next year. They're going to do that. Because they don't actually dislike him. The people who do dislike him are never going to invite him back, and that's fine. They just aren't. Nothing you can do will change that. And the people who are already going to invite him are already going to invite him again. So, there you go. So that's that was a long-winded answer, but it was a really good question. So I wanted to give it as much thought and perspective as I could. I hope that helps, Fluffy. Great question. Hypothetically, if I was Vic's counsel, that's where I go. Brief recap. Funimation clarifying their statement saying, found no instances of sexual misconduct. Even if they say, we're still not going to work with him ever again, everybody will understand that's because suing your employer is, you're never going to work with them again. And then agreements to non-disparagement from the rest of the parties. Oh, and you pay your own damn fees. Pay your own fees. That's not changing. But paying out a bunch of money to them, I don't see that happening. Not when they've destroyed his income. I'd best not forget the hashtags. Dang it, I did. Let's go back. Okay, so we've got Cuck Lightyear and 2 Bankruptcy and Beyond. All right. So back to the judge's soliloquy. Here, this paragraph to me rings like he just got beat up by the Supreme Court of Texas a bit ago. Stupid Fly Coon is still alive. He got beat up by the Supreme Court of Texas a bit ago, came back through his court. They're going to hear it again. He's afraid of getting beat up. The appeals court, he's got to know that there's a high likelihood that many of these decisions get overturned on appeal. He knows. He knows. So then he goes in, but before I rule on the rest of it, I'd rather you try and get this worked out. That's a weird decision. This is really a weird decision. Not because mediation is that weird of a decision. And a dummy on Twitter has talked about how judges do this before rendering their final ruling or their ruling on damages all the time. Yeah, but the judge hasn't actually issued a final ruling. He's left 5 very important causes of action on the table, and he hasn't really indicated how he's going to go on those. So you can't just say that the judge is just allowing them to mediate before he does damages because it'll be easier and not appealable and all that stuff. I mean, those are kind of true, but he does have 5 causes of action out on the table. And the real problem is 3 of those causes of action are huge. The 3 biggest causes of action in the lawsuit: defamation on Funimation, defamation on Real, and defamation on Toye. Those are the 3 biggest money damages causes of action. He hasn't ruled on them, and he's going to ask people to go into mediation with uncertainty. Now, he could issue... Here's an alternative proposition to the idiot who said that. You know who you are, and I know you pretend you don't watch my show, but I know you do. An alternative proposition would be he would issue the ruling, and then before the damages hearing or the damages proposed order that's going to come through, he would order them to mediation on the damages. That would be a much wiser sort of decision for what you're saying. That, oh, judges do this all the time before damages. Yeah, but he hasn't even finished his ruling yet. He hasn't indicated which way he's going to rule. So the parties are all on their own perspective. And a couple of these parties have been huffing their own farts the entire time. So they're going to think that that they have no problems going into this mediation. Which again, I think when they get there, they're going to have a rude awakening. I think y'all have the opportunity to heal the community by doing something that y'all can agree on. This statement is really interesting for a couple reasons. Now, one could suggest that this is a result of some improper communications to the judge from Monica Rial, who has said several of the same things. We're out in conspiracy theory territory. I have no information about this. Okay? To be clear, I'm not saying this happened. One could suggest that that's a result of either improper communication or a significant indication of bias towards the judge, because he's basically verbatim quoting Monica Rial over the past couple days leading up to this hearing. All right? Or we can take it a different way. And that's what this show is all about, right? Going back and forth on how these things could be interpreted. He might be indicating, this is based on a theory from before, he handpicked this mediator. If he knows the mediator and is looking to gauge the positions of the parties, their willingness to compromise, their attitude in general, he's doing that. He's signaling right now to Monica Rial, you've said you want the community to heal. Show it. And if you don't show it, maybe your defamation goes through and you have to fight it. That's another way to look at this. And again, I don't know. You guys have, this is just talking, and you guys get to make your determinations. I'm trying to offer you different avenues of how to look at things. And this is part of the educational mission of this channel, is to, outside of just legal proceedings. And I know there are very, very good legal minds like Mike Dunford, who admitted today to never even considering the appeal bond issue because he's not practicing to avoid specific things like that. He just wants to teach. Hey, fucking resign, Mike. Just quit. Go work at as a Walmart greeter like you look. Go do that. Because if you're not willing, if you're going to go out there and teach people who are paying you hundreds of thousands of dollars to learn to practice law, and you're openly stating that you never intended to learn how to practice law, but you're just going to go teach the theory of law, oh my gosh, neck yourself in Minecraft, man. No one needs that in their lives. They would be much better served by a retired copyright attorney who could actually tell them how to practice law rather than the theory behind it. Because as you've learned from an actual copyright practitioner in one of my own threads, you moron, what you think about how law works ain't how it works in actual practice. And a practitioner came in and just blew you out on an issue because you're an idiot. You don't actually want to do this. And you're purporting to tell kids, I call them kids, they're 24, to tell young adults to come in and give you thousands and thousands of tuition dollars to prep them for the future. And they're going to get out of law school and they're going to have no idea what to do. Because you didn't want to learn about appellate bonds and you didn't want to learn about the messy part of collecting money for law. You just wanted to learn how to read. Well, everybody can learn how to read a copyright case. Everybody can teach kids how to read a copyright case with enough study. That's not valuable. What would be valuable is to have an actual practitioner come in there and tell them how to practice law. You're the problem with law school, Mike, and you know it. And that's disgusting. Okay. Anyway, sorry, rant. Sorry, minor rant. Okay. So I think this heal the community can be looked at two ways. It can be looked at him as being sympathetic to Monica or being biased towards Monica if you want to go kind of the conspiracy route. If you want to go the Chup is really clever route, this is a signal. I'm watching you. I'm watching how reasonable you are going into this mediation. If you go into this mediation and say, well, I won't accept any settlement short of Vic Minecrafting himself, and that gets back to Judge Chup, that might have something to do with how he rules. I don't know. Or he could mean nothing by it because he could be an absent-minded judge. I don't know. As opposed to having me do something and then y'all having to appeal it and go through all that process, and it just comes back here again. This, again, I'm going to say, I mean, this could go on years. This is a signal to them. He says he doesn't know how the appeals court's going to rule, and that's academically correct. In practice, I think Judge Chup has looked at the record here and knows that some of these issues come back on appeal. Maybe more than once. Because some of his issues have just come back on appeal more than once. If you think that's not weighing on his mind, it absolutely is. I'd rather just obviously see the community of anime get healed and move on and do what you need to do. I don't think he cares at all about the community of anime. Frankly, I don't think Judge Chup has any understanding of what the community of anime even is. I would wager that no one has any idea what this term, community of anime, means at all. And if they asserted what it meant, they would get called a flaggot on Reddit and get thrown off, right? Like there's no one who can define what the anime community is. And if you try to, you'll get a bunch of people telling you you're wrong, period. Okay, so that's all I needed. I just wanted to tell y'all in person because I thought it was rather serious with regards to, and I don't know what all is out there. That's just what I was given. And so there could be much more than that. I don't know, but just watch your back. Yeah, Judge seems really concerned about those non-threats. Bullock says, thank you, Judge. Volney, thank you. Court, all right. Y'all have a good day. And that's the end. That's the end. Hashtags, we've got hashtag no time for clients. Hashtag 200 TPM. I'm assuming that's tweets per minute. Hashtag sun free life. Oh! R.I.P. the deadbeat dad crew. Greg Doucette and Ron Toye. Hashtag 99 problems, but a son ain't one. Oh, come on. Be honest, those kids are better off. This is Christina Fett's certification. This is correct. Hashtag notice me Popat Senpai. Hashtag I love you frown. Whoever did those hashtags, hilarious. Hilarious job. Okay, let me go back to this view for just a minute. And then what we're gonna do, I'm gonna do Law Twitter a favor and we'll pull up the bond statute. Civil Practice and Remedies Code, Rule Chapter 52, Section 52.001. Let's take a look at this. And might zoom this in just a bit. Y'all will be able to see this. I know you can't see it yet. We'll pull it up. Texas rules appellate procedure. It's rule, hold on, I'm pulling this up. 24.2. Now this is right there in the open. I hadn't really researched this until today because, you know, I'm not a Texas practitioner. I've never claimed to be an expert. Here we go. 24.1, 24.2. Okay. Let's take a peek at this. There we go. All right, so this is Rule 24. So this is a Texas Rules of Appellate Procedure, okay? Texas Rules of Appellate Procedure. This was out there in the open. When I cited to a Supreme Court case affirming what the plain language of this statute said, a bunch of really, really smart law Twitter people demanded citations, suggested I was wrong, suggested I didn't know what I was talking about and all of that stuff. The same thing they always do when I turn out to be correct. But and then, of course, later in the day, they said, oh, we actually talked about this weeks ago. We already knew it. I mean, they spent the early part of the day telling me I was wrong. And then later in the day saying I was stupid for not knowing what they had already talked about before. So very fun. Very fun. They're such a delightful group of people. All right, so here we go. So suspension of enforcement of judgment pending appeal in civil cases. All right, so a judgment, obviously, TCPA issues a judgment. That judgment is for attorney's fees, court costs, and sanctions. All right, with me? That's the judgment that you get as the plaintiff if you lose at TCPA. There isn't any sort of damages outside of attorney's fees, costs, and sanctions. All right, so suspension of enforcement. So this is how you suspend the enforcement of that judgment. Filing with trial court clerk a written agreement with the judgment creditor for suspending enforcement of the judgment. So if you agree with the other party, we're going to hold off pending the appeal. Fine. Filing with the trial clerk a good and sufficient bond. So you can post a bond for the amount. Making a deposit with the trial court clerk in lieu of a bond. So you can deposit the full amount. Let's say you owe $100,000. We're going to use $100,000 as our hypothetical number here. And then providing alternate security ordered by the court. So you're ordered $100,000 in attorney's fees. Well, no, not attorney's fees. In damages, economic damages. Well, then you have to either post $100,000 or you have to post a $100,000 bond or you have to provide alternate security ordered by the court in lieu of the $100,000. Say you don't have $100,000 cash, but you have a house that's worth $150,000. The court could alternatively in order, for example, a lien for $100,000 be placed on your house, a judgment lien. They could do that. Now, what circumstances would lead the court to do that is a different question. Okay, so a bond, here's the rules on a bond. Here's a type of deposits, cashier's check, negotiable obligation of the federal government, so like a treasury bond. And then, yeah. This is how you avoid the enforcement of a judgment or suspend the enforcement of a judgment. Doesn't mean it goes away. Just means that during the appeals process, you don't have to pay because you put up security, okay? Now, let's look at Rule 24.2. 24.2, amount of bond, deposit, or security. So this is not just covering the rules of bonds, it's the amount of the bond or the deposit or the security. So, type of judgment for recovery of money. So you're ordered $100,000 in economic damages. When the judgment is for money, the amount of the bond, deposit, or security must equal the sum of compensatory damages awarded in the judgment. That's your economic damages. Interest for the estimated duration of the appeal. If it's going to be a year, you got to put a year of interest included. And costs awarded in the judgment. These are all terms of art in law and have specific meanings, but the amount must not exceed the lesser of. Let's talk about this. Compensatory damages are direct economic damages, not special damages, not exemplary damages. So if you, for example, one thing we've talked about in this case is exemplary damages. If you lose a defamation claim and you don't mitigate the loss by complying with the TDMA letter, then they can get up to 3 times the compensatory damages in exemplary or special damages, right? That's in the statute. So you make a defamatory statement, you don't retract it within the 30 days from the TDMA letter, you go to trial, you lose, the judge or jury can order up to triple damages as special or exemplary damages, all right? That is not compensatory damages. Compensatory damages is just the initial damage, the economic loss that you suffered. The reputational harm that's replaced by money is compensatory damages. The interest is the interest on that compensatory amount. And then finally, costs are court costs or other costs as justifiable. Those are not fees. Often you will see costs and fees together in the statement requesting relief. Costs and fees as justice requires, something like that. It's because costs are distinct from fees. Costs are court costs, filing fees, courier fees, stuff like that, mailing fees. Those are going to be very low. We're talking in the neighborhood of a couple $100 per party to maybe $1,000 to $2,000 per party of costs. And then that's it. So in Vic's case, if Vic were to lose all counts, he's not going to be, or they're not going to be awarded compensatory damages at all. There is no compensatory damage as a defendant in a case that is defeated on TCPA. There are fees, attorney fees, right? That's the big one. And those are not costs. Those are not compensatory damages. There's no special damages. Sanctions aren't included in costs or compensatory damages either. Sanctions are a special type of damage. They are specific types of damage, and they're not covered here. There's a bunch of Supreme Court cases affirming all of this. I want to point out that the best and brightest of law Twitter, really, Elsa and Bedek, you guys are stupid. And it's cute, but it gets old after a while. Suggested that this wasn't true, but it is true. It is. And there's actually, if you look carefully, there is a Texas practitioner politely trying to tell them, no, Nick is actually right on this, and it's true. And his any bond that he would have to post would be really small. Okay. So this is Texas Rules of Appellate Procedure. Here's the Civil Practice and Remedies Code. Here's the second statute on it, just in case they didn't figure it out from the other one. This is all Punitive damages are exemplary or special damages, also Corona. They're separate from all this. Here is the Civil Practice and Remedies Code, Title 2, Chapter 52, Security for Judgments Pending Appeal. So, in this chapter, security means a bond or deposit posted as provided by the Texas Rules of Appellate Procedure. So here's the statute enacting this. Conflict with the Texas Rules of Appellate Procedure. To the extent this chapter conflicts with the rules, this chapter controls. Okay, so if there's any conflict, this chapter wins. So here we go. Amount of security for money judgment. Subject to subsection B, when a judgment is for money, the amount of security must equal the sum of the amount of compensatory damages awarded in the judgment, interest for the estimated duration of the appeal, and costs awarded in the judgment. Notice there is no conflict at this point. B, notwithstanding any other law or rules of court, when a judgment is for money, the amount of security must not exceed the lesser of 50% of the judgment debtor's net worth or $25 million. So it can never be more than 50% of your net worth or 25 million, whichever is lower. If you're worth $100 million, it's going to be $25 million. If the total tallies up. If you're worth $10 million, then it could only be up to $5 million. Again, if compensatory damages reach that high. Then on a showing by the judgment debtor is likely to suffer substantial economic harm if required to post security in the amount required under subsection A or B. Trial court shall lower the amount of the security to an amount that will not cause a judgment debtor substantial economic harm. You can't make someone destitute and unable to pay their own cost of living with the security. And then an appellate court may review the amount of security as allowed under Rule 24, except when a judgment is for money. Appellate court may not modify the amount of security to exceed the amount allowed under this section. So they can only lower it or raise it up to the maximum. And then finally, nothing in this section prevents a trial court from enjoining the judgment debtor from dissipating or transferring assets. So trial court can say you can't sell your property off or transfer it to a trust or a charity or your best friend or whatever. You can't just get rid of your assets to say that you don't have any. Okay? So the trial court can order that. Now, of course, that order is not typically retroactive. That would be following. But I want to point this out. These are the laws that are on the books. Their language is plain. Their language is plain, you idiots, on Law Twitter. I wasn't lying about it. And you didn't need a citation. It's in the frickin' statute. It's in the rules. It's plainly written. And the appellate procedure rules are basically the exact same. If you look at, there's a couple extra things for other judgment for property and stuff like that, or custody or government entity. And then it's got this other stuff. And then it's got rules on how you determine net worth and stuff like that. But there isn't really a conflict there. And they both say the same thing. Now, let's say, for example, Chup and the appellate court all take LSD and go crazy. And they say that Vic has to put up the money. This isn't true. The likelihood of this is 0.01% or something like that. The real likelihood is that any amount that Vic would have to put up for security is probably 4 figures of money. Couple $1,000 up to maybe $8,000, $9,000. Unlikely that high. Likely, if we're taking all defendants, there are 4 defendants, all their filing fees and courier fees, I'd say $8,000 is probably a cap on how much he would have to put up to appeal. Now, let's say all of his cause of action are dismissed and he's ordered to pay $200,000 in fees. Is he going to put $8,000? Is he going to put $8,000 down to appeal that? Absolutely. I think that is likely. I think that, nope, I'm just going to go home and pay 6 figures of money to these people. I think that's less likely. But $8,000 for security. Okay, cool. So we've established that. But let's say Crazy Town happens and Vic has to put up a bond for the full amount, or they determine that sanctions are part of it. That would be going against predominant case law. It would probably get a writ of mandamus and be immediately fixed. But just in case they said that. Here's how appeal bonds work. And here's another sort of point of education, I guess. Go channel. Appeal bonds are where you give a percentage of the money to a bonding company and then a promise to provide the rest of the money to that bonding company, and they put up the full amount. In criminal cases around here, if you need a bail bond, for example, the amount that you put up is 11%. It's 10% to the bond company and then another 1% as a fee to the bond company. So if you have a $20,000 bond, it's $2,250. All right. So worst case scenario, let's say the nightmare scenario occurs. Vic is ordered to pay $500,000 in fees and he has to put up the bond for it. Likely at that point, you're talking about 50 grand that he puts up. And if you're faced with putting up a $50,000 bond to continue with the appeals or $500,000, you're going to put up the 50 million or pay out $500,000. You're probably going to put up the 50 grand and take it to appeals because you could probably appeal that ridiculous decision on the fee amounts as well. Because remember, the TCPA only awards costs and fees related to the filing of the TCPA. Their discovery nonsense beforehand is arguably not related at all to the TCPA, and many of their rulings could actually be potentially determined to be frivolous or for padding the bill, for purposes of padding the bill. And if Jay Sean happens to have any tweets about that, that would be really unfortunate as well. But the idea that they might try to overload the court with a bunch of frivolous garbage would not increase their filing fees, or would be a point of argument about their fees, so to speak. But anyway, that's the worst case scenario, a 10% bond. That's for criminal bonds. Civil bonds are often somewhere in the neighborhood of 5%. And there's no rule on what bond amount you need to put up. You can actually get a 1% bond. So let's stick with that $500,000 figure. Let's say there are a bond company out there to be willing to offer Vic a 1% bond. Okay. Then suddenly he's paying $5 grand. Now he has to promise to the bond company that he's going to put up $500K, because at the end of the day, if he loses, the bond company has to pay the $500K and they're going to come after him for it, right? Like that's a real possibility there. But again, I have to point out that attorney's fees are not part of the bond or security, so he wouldn't have to do this. This is just an extreme, ridiculous hypothetical that would probably get a writ of mandamus directly from the appeals court or Supreme Court, slapping that idea straight into the dirt and just ordering him to pay what's actually written in the statute and established by case law. But I digress. I wonder if Vic knows anybody who knows any bond companies and is friendly with them in Texas. I wonder if he does. I don't know, of course. We'll have to see. Actually, we probably won't have to see, because the reality is whatever fee, if he has, and he has appeals, right? He definitely has appeals and a suspension of judgment pending appeal that he would want to do. Again, unless the judge comes in and entirely undoes all the decisions, no matter what the judge does going forward. The only time where Vic doesn't have an appeal at this point is if he goes into settlement and actually settles at the mediation. Otherwise, he's got appeals and he's got a good case for several of those appeals. If not all of them, many of them. Oh, and the TCPA doesn't award attorney's fees for your appellate case. Again, it's the filing of the TCPA. You don't necessarily win fees on the appellate case. You can make an argument that they should award fees on the appellate case, and they may do so, but that's not a foregone conclusion like it is in the lower case. So, let's just calm our tits on whether or not Vic will appeal. Vic has every reason in the book to appeal any of the decisions that have gone against him at this point. He just does. Unless a judge comes in and says, well, fees are $2,000, which he won't say that. But if the judge gave some extremely low fee amount, maybe Vic pays it and doesn't appeal if he doesn't think he has a strong cause of action against the person at this point. but everything likely will probably be appealed. Even if the current cause of action go through, that stuff's likely going to be appealed. So any of you out there in Conslut land who think you're going to get like a payout in the next couple months, yeah, I'd hold your horses on that one. Hold your Monica Rial's teeth on that one. You're not going to get paid until the full case is fully resolved if you win. Period. And if you think that, because why this all came up is there was some chatter that Vic's posting of the bond would be such a deterrent because he'd have to give all of this money over to the defendants to just have the opportunity to appeal, and that would deter him. First of all, that's just logically stupid. Second of all, it's not legally accurate. And I wanted to point that out because there's a lot of spiking footballs and dancing on graves and all of that crap that's gone on. And a lot of it's based on misinformation. So clearing that up, also helping foster the discussion in some. Even if Vic loses every single thing, even if he loses every single thing and the judge awards a huge attorney's fees and sanctions damages award to all of the defendants, to appeal, Vic probably has to put up less than $10,000, maybe even less than $1,000 if he bonds out that tiny amount. So just so you know, there's very little chance that outside of settlement that this thing doesn't go for the long haul. And all of the theories as to why boil down to people absolutely misunderstanding how Texas applies this law. So there you go. Hopefully that was educational to you. Hopefully that was helpful in your discussions. Because again, I love reading up on like Kiwi Farms and on Twitter when people aren't wasting their time dunking and they're actually trying to noodle this out. Conversations are very interesting, and I love lurking and looking at them and seeing what people think about it. Because I'm having the same discussions, either in direct messages or on my Discord or with personal contacts that I know. I'm asking them, I'm trying to figure out, what motivations are going on here, what the strategy is and all that stuff. This is interesting stuff. So I'm doing the same thing. I love watching y'all's conversations, and I want to make sure they're as informed as possible. So wait a minute. So the GoFundMe, I'm supposed to shill it again? Let me do it one more time. One more time for the GoFundMe, and then we're going to do super chats. So here we go. Here's the GoFundMe again. We're at $248,551. Thanks to Anonymous, Marcus Leon, Anonymous, Joshua Santos. Those have donated since we last looked. Again, we're under $1,500 away from $250,000. I did get informed by Ken, the guy created the two knives that I have. The third knife and sheath is almost done, and they're on the way very soon. I can't offer those as a contest through GoFundMe. GoFundMe's payment processor will not allow them to process a payment that would end up with a weapon being delivered to someone. And they've determined that those knives are weapons under their definitions. They checked specifically with their payment processor. I want to be clear, this didn't come from GoFundMe. It came from the person who processes their payments. And if you haven't heard one of my streams about the disgusting tyranny of payment processors and how that is going to ruin all of us in the near future, go find one of those rants or discussions with me and Null and engage in that. We'll have another one before too long. Payment processors are Satan. And just wait till those payment processors decide that you have a blackface picture like Trudeau and that you're no longer allowed to buy groceries, because if the grocery store processes payments for a racist like that, then they'll stop processing payments for the grocery store. And if you think I'm kidding, it already happens. So anyway, Long story short, we will be finding a way to auction off those knives that does not go through GoFundMe because we're not allowed to. We will find a way to do it. I'm noodling through how it works. And even if it's done in a private sort of stream with only interested buyers or whatever, and we have to do it in some nominal way, we will do it. We'll do an auction of these things. Maybe it'll be a silent auction that is manually curated or something like that. And then we'll transfer that money into the GoFundMe, which will be just a donation based on proceeds. And they can't really mess with that. And it's not processed through their website or anything. I would much rather have people able to do what they did with the prints, but we can't. So anyway, so there you go. Like I said, there's a long road ahead of us on the GoFundMe. But personally, if I were you, this is how bad of a salesman I am. Terrible. Worst salesman ever. He fired immediately for my employment. I would hold off on donating if you're at all unsure about anything. Okay? If you want to wait and see how the mediation kicks out, if you want to wait and see how CHUP rules or what the damages awards are, or see how the case progresses on appeal, hold off. Don't put money in it unless you are comfortable supporting Vic at this point and knowing what you know. I've never, ever asked people to support on faith. So if you believe in Vic, if you believe in this cause, if you believe in standing up against this stuff, and you're able to, donate to the GoFundMe. If you can't, if you don't believe in those things, don't do it. Please. Never ask anybody to give outside their means. I would never ask anybody to give for something that they wouldn't believe in. And I would, because I'm telling you, if I was at this stage, I would be considering any donations I made saying, okay, I don't know what's going to happen right now. I understand. And you don't ever offend me by making those decisions on what's right for you. Like I said, worst salesman on earth, terrible grifter, but there you go. Make those determinations as you see fit. If you need to talk to me, there are several ways to reach me, and I will try to get back to you. If you have any questions, I do try and answer them. Yeah, there you go. All right, guys, we have got. Someone's asking if you can't you go to jail for lying in an affidavit? Yeah, you can, but it has to be pretty specific, and people usually don't. All right. Next thing, we're about to enter into Super Chat and Justice Chat modes and wrap up the show. Man, we actually will go the full 3 hours tonight. The full 3 hours. I didn't think we would, but I'm glad that we did. I'm going to read through the chats, the Justice Chats and the Super Chats. That should take us right up till 2 a.m. Central. I will be going to Twitch afterwards. I'm debating between Risk of Rain and Path of Exile. I haven't decided which one to do yet. Because I'm really enjoying Path of Exile, but I really want to do some of those Risk of Rain achievements. Anyway, if you're someone who pieces out for the Super Chats, I'll catch you later. Come watch tomorrow. Drexel should be on. I will confirm it on Twitter as soon as it's fully confirmed. If you're going to hang out through the Super Chats, hang out through the Super Chats, and we'll do the outro song and all of that. Otherwise, peace. See you later. See you tomorrow. Let's do it. Mercenary X says, so Nick, did you see the 4chan IRL raid? They started another poster campaign. Islam is right about women is the new it's okay to be white. Also, channel Down the Rabbit Hole did a 2-hour video on Wings of Redemption. Check it out. And Air Force Proud 95. So there you go. Ricky. Oh, wait, I read that one. Kay says, there's no way Ty will get anything out of mediation outside of maybe Markey forgoing appeal potential in exchange for no fees awarded. Otherwise, they'll just stonewall and try to demean Vic at mediation. Will mediation records be public? No. And stonewalling and demeaning Vic at mediation likely won't go very far because Vic probably, in this case, at least won't start in the same room as the defendants. And the mediator will be a go-between. And demeaning the other party to the mediator only makes you look like a chump. Mediator doesn't care about that. If you're like, oh, that guy's a creeper or whatever, the mediator's going to say, yeah, we're not here for that. What's your walk away on this? And if your walk away is nothing, let's wrap it up. But if we're here to deal, let's deal. That's what a good mediator does. And that's what parties also recognize. If the mediator says, look, they're not really willing to do anything, and you say, okay, peace, and you leave. You tried your mediation, it failed. Now let's see where the chips fall. So, no way Ty will get anything out of mediation. Oh, excuse me. May be true, but Ty didn't ask for the mediation. Judge did. So you comply because the judge has ordered you to. TLJ Screwjob says, how is that a huge victory? People who are saying Funimation investigated him, he must be guilty. They won't care that the right-wing judge forced them to say it. That's actually not forcing someone to say it. That would be Funimation agreeing to say it and clarifying it. Like the courting lawsuit, the guy was smirking and saying, I don't think Jeremy Hambly is a Nazi. Neither will Lynn Hunt. Well, Lynn Hunt is stupid. I don't think that many people are paying much attention to Lynn Hunt. They're paying a lot of attention to the fact that Funimation fired him, and they said that he was fired after an investigation into sexual assault. So she'll just keep going to cons and trying to get him canceled, and then eventually she'll get sued for that. I mean, eventually that'll happen. Or the cons will finally tell her to shut up because no one wants to hear that man jaw flapping. Everyone will know that funny doesn't actually mean it. Well, I mean, you can disagree with me on that. You certainly can. But I think it's very, very likely that Funimation's statements have caused him the most, if not much of the harm. And that those statements being walked back officially by a company is very different than someone named Prettiest Matt walking them back. I really do. I think that's a big deal. I think Vic could take that to conventions and say, look, it was a misunderstanding, got out of hand, and it was exploded by a couple people who decided to run with it and lie about me. Finally, TLG Screwjob says, so I know you've answered this before, but what if Rooster Teeth goes under when Vic can still sue them in the 1-year window? Because, you know, they had to lay off 13% of their workforce. Hashtag karma, hashtag for firing Vic. If they go under, they go under. Then Vic wins. I mean, then firing Vic was a bad idea, I guess. I find it very interesting also that, you know, Funimation, not that I've been doing any research, but Funimation has some interesting models of business in that they have a streaming business, which is going to be almost, you know, de minimis on cost and heavily margined. They have a very real possibility of angering a lot of fans of Vic to the point where they may not subscribe to Funimation anymore. Vic hasn't actually done anything. He's never said anything publicly about how he was treated by Funimation and stuff like that. I think that Funimation might have a real interest in paying attention to just how many people actively support Vic. Because the defendants have bleated and whined about Vic has asked people to harass anyone. Vic never asked anybody to harass anybody. Because I think if Vic had actually asked people to harass the other parties, they would have real issues on their hands. Vic has never done that. And Funimation, depending on their business model, may understand what would happen if Vic did do that. I think it would be really detrimental to them. Vic has 113,000 followers on Twitter. Who knows how many of those subscribe to Funimation? If they do subscribe to Funimation and Funimation, you know, pisses them off enough, and they were to lose a substantial amount of people, subscriptions, I mean, those subscriptions are all revenue. So like a $6 or $7 a month subscription, whatever it is, And that's revenue, and very little cost involved with that revenue. Their costs of producing the anime are nothing because they pay their employees like garbage. That's just money. But that money is baked into other costs of the company. And if that money disappears, which is something that's really easy for subscribers to do, is to click unsubscribe and not pay for it. There's lots of places to get anime. If they do that, Funimation is in real financial trouble. And I mean real financial trouble really fast. I've looked at the numbers. And it's really quick how much revenue they lose. I've talked about this before, or Ty talked about it on the show. I don't remember. But when you have a company like Funimation, whose costs are basically fixed, right? They have an expected amount of costs. They have salaried employees, and then they have their voice actor costs. They don't have royalty costs or anything like that. They know what their license agreement costs. They know what their production, because they outsource their production and distribution. They know what that's going to cost, and they know what the streaming services cost, and they know how much all of this stuff brings in. Losing 10% of your revenue in one of your business lines, especially one of your biggest business lines, could put a company out of business that fast. 5% hit could put a company out of business. What's the math? I think the math is that Funimation has somewhere around 500 to 600,000 subscribers to their online streaming service, at least as far as 2018 goes. If 100,000 people like Vic and remove themselves, that's 20% of that business line's revenue. That puts Funimation in a place where they may not make payroll, and they may be in bankruptcy. Like that's how precarious their position is. Very interesting stuff. As for Rooster Teeth, who cares? They're going to go out of the business pretty soon anyways. Mercenary X finally is the last Justice Chat here, says, before I forget, look up a video by Seth Sinch in his video on Space Station 13. I have to warn you that I was laughing so hard I almost choked myself by lack of air. This is the funniest thing I've ever heard since Air Force Proud 95 videos. Okay, let's go to Super Chats. Blink Your Eyes 1400 says, October 3rd is when Ed and Al burned their home and went on their journey to get their bodies back in Full Metal Alchemist. Just saying. Just saying. Gimme Skittles Now says, can you update your SoundCloud? It's months behind. Yes, I'm sorry. I will work on it. Jay says, hot accountant, thought that counts. Sorry, not sorry. Oh, by the way, if there are any former Funimation accountants out there, I would love to talk to you. Andrew War Snowboard says, Justin Trudeau, officially SJW, Canuck like Maddox. Fatal System Error says, 20 seconds early. Good job. Hey, you're welcome. Or thanks. Young Beyblade says, what could Vic settle for in mediation? What could they give him? They've already ruined his reputation and career. I've made myself, I've laid that out pretty clearly, I believe. Kilroy was here, says, it's official. Soye is going to bring Rackets a Carolina Reaper using his snack tray for the 75K substream. To Transcriber Kun, Ron Toye is a CUCK. Mario Carter 13 says, Sabat smeared more holes than Trudeau with shoe polish. Aww. D-Man Dog 56 says, if someone tried to buy the rights to the entire Ruby IP and franchise from WB when Rooster Teeth dies, how would one go about doing it? Can you lawsplain? I can't do that now, but you'd probably be surprised. You basically inquire with them about what they want for the IP. It's likely part of a package, and they'll tell you the amount, and then you put it up. That's about it. Isabel Cadence says, hi, Nick. You're awesome. Love you. Okay, bye. Hey, thank you. Charles Turner says, so riding Drexel is really interesting. Sure. Asia Fraser says, in Pinky and Brain voices, what are we going to do tonight, Nick? Same thing we do every night. Try to grift over the world. That's a terrible Brain voice. Sorry. Probably a terrible Pinky. I haven't actually heard Pinky and the Brain's voices for a long time. Kara Papa says, are you going to go through the TCPA hearing transcript? I don't know. Other people have done it. John Michael Kelly's done it. I'm sure that's insightful. I'm not sure I want to do that. I guess I could, but that's like several episodes of content. I've already given my thoughts on it. You guys can read it. I don't know. We'll see. Let's see. Finn Frog says underage girls going topless is now legal in Utah, Colorado, Wyoming, New Mexico, Kansas, and Oklahoma. Hooray for feminism. Honk honk. Harbinger 345 says, I don't come for the law or laughing at dummies or even the drinks. I come for the classiest of things. Nick's amazing boomerang skill. Oh, thank you. Thank you. Talbot Link says, I resent you for the contact info for, resent you. I thought you said I resent you. I did see that. I resent you the contact info for Phil/Dollhouse. Subject line, the Dollhouse contact info. Yes, I saw that. Thank you so much. I will reach out to him. Horace Cock Johnson says, thoughts on Colt refusing to sell AR-15s to civilians. Hashtag F Colt. Well, screw him. Burn it all. Burn it all to the ground. In Minecraft. I don't mean literally. I mean metaphorically. Time Traveler registered trademark says Harvey Birdman theme song intensifies. Matthew Neidig says, cheers, Nick. I'm cracking open this Highland Magnus. Cap off my 29th birthday. Hey, happy birthday, buddy. Here's to you and yours and another interesting year. Thanks, man. Pendergast21 says, do you think the judge will miss the date and end up doing a pocket veto just so no one will look at how bad he handled the TCPA procedure? The pocket veto won't get everybody. Like, I think at this point he would have to actively overturn his bench rulings. But he may do a pocket veto on the other 5. He may do that. Kalinka Pavlova says, I'm late and gay because it's Friday here. I thought it was the Drexel stream tonight. It's the Drexel stream tonight, my time. Also, why is Flaw Twitter /KickVic misrepresenting this document? Scared much? I don't know. They're so weird. They're wrapped up in their own myopia. It seems. L. Raver Jesus says, speaking of sacred ointment, I had to make that idea into a perler pattern. I gave it away to another V supporter at a rave. It's so worth it, lol. I'll post up a pic to Twitter if I can, lol. Much love. Hey, much love back to you. Snarkticon DM says that Evan Stone pic looks like Sabbath. No one important says, not again, Sabbath. It's amazing. It's amazing what their competitor is doing with their IP. Kalinka Pavlova says, did Toei okay their IP being used on this ad? I don't know. Trey Lilly says, Evan Stone graduated from UNT with a film degree. Great. That's what I'm doing. Oh, good luck, buddy. Kara Papa says that was almost as cringe as Arms Girl's EVA cover. Don't ever mention that again. That was disgusting. Bro Lock Eye says, reminds me of when 4Kids Entertainment had their original IPs along with the licensed anime characters sing the American National Anthem. Lol, look it up, people. Kilroy was here, says, I can only imagine how much mainstream ridicule a Republican judge would get if they did a political ad like that. Well, I don't think that Evan did too well in that election, but maybe he did well. He didn't win, though. Grievous Error says, con slots. Wing012 says, no matter what, Ron will not get away. Bad Dragonite says, rent that theater and play some MF and Halo on it. That would be fun. Alexis Deanna Monroe says, regardless whether Vic wins or loses, I will still remain a fan. He's one of the best, greatest of all time voice actors. Oh, excuse me. He's such a sweet soul. How do I know? Because I listen with my heart. That's nice. Danny Agent 87 says judges should be replaced with an AI-based system. I'm actually listening to a book about that, and there's a lot of merit to it. Danny Agent 87 also says, time to mark first year anniversary of Meyer versus Wade. That's right. Meyer versus Wade has been going on for a year and is still not out of the jurisdictional dispute. That's the pace of a normal federal lawsuit. So there you go. Rick U1186 says, Nick, I feel you said all this before. Did you say all this before? I feel like you said all this at the start. I might have. That guy says, F those figs, they all lie. Bad Dragonite says, giant cooler of Milo's at BoomerCon or Riot. Oh, that's good. maybe I could get Milos to just send me a huge amount. Days of Clarity says Monica said Broly will be recast. What good faith. Yeah, well, I don't think anybody's under the illusion that Vic is going back to Funimation at this point. No one important says, in fact, if you just go by Vic's Twitter page, you wouldn't even know about the case. Vic knows how to be a professional. He does. Automata says, consider talking about that Verge article, Anime Trolls with Drexel. Curious about how closely he'd relate to that sort of rally the White Knight dynamic he feels might be reiterating. That's a good idea. That's a good idea. All Out of Bubblegum says, I waited until I got home before watching. That's good. Kidda says, Warner Brothers won't sell any IP. The Asheron's Call player base tried to buy Asheron's Call after WB lied and shut the game down instead of making it open source as they promised. They refused despite no value in keeping it. And Comic-Con Freak says October 3rd has a Full Metal Alchemist reference, but it's also Mean Girls Day. Pretty ironic. It's also my birthday. That's going to be a big day. Lol. All right. All right. Well, thank you guys for joining me tonight. Thanks for hanging out on the stream. I'm going to go get another drink because my voice is dying. Just so you know, part of the reason I canceled yesterday's stream is because I'm getting ready for HawaiiCon and all of that stuff. But at the same time, my youngest has been back and forth on being sick. And I think I've been fighting it off for like a week now. And I'm trying not to succumb. So there you go. But I'll be over on Twitch. I'm probably going to play Path of Exile like an idiot. Probably. Anyway, come join me. Ask your questions. Like I said, Twitch streams always have way less people than the YouTube streams, and I'm generally able to answer questions without like a super chat or monetary value attached. I try to be engaged with the chat as much as possible. Depends on the day, how tired I am and all that stuff, but I really do try to engage there. So if you're not a person who likes to donate money, but you still want to engage and ask questions, come over to Twitch. There's no, it's much easier and for me to follow over there. So come on over. Trent Michael says, show idea, Google Ed Buck. Interesting stuff. All right. Oh, let's do this. Turn that volume down a bit. All right, the outro song is playing. You know what that means. That means that we are going to be ending the show here, and we will be picking up the show tomorrow. So again, come join. Hopefully, like 99% right now, Drexel and I will confirm it on Twitter tomorrow as soon as I know for sure that it's happening. Thanks for hanging out and watching tonight. Thanks for all of your interesting conversation that you guys do both on the stream and off the stream. And we'll see you soon. All right? I think we covered it. Peace. Peace.
Make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an art bag, a bow, more of love Freud. The spirits flow as the ones who get unemployed. So pour out a glass for the tea, post on Twitter as we hear lawsplaining tonight. From the white shores of Nam to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, the guests are all planet folks from Dante to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Bag about get unemployed. So pour out a glass for the tea, post on Twitter as we hear lawsplaining tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we are now.